Good morning, everybody. We are just about here at 8:30, so I thought as people gather in and settle on into a spot, we'd get started. Welcome to the first hour of our CLE program, Working Together, Client Capacity Concerns. This hour's focus is on community mental health concerns and involuntary commitments. My name is Eric Hansen. I'm a member of the State Bar of South Dakota CLE Committee and serve as one of today's CLE programming chairs. Before I introduce today's program, I will provide a few housekeeping notes and announcements. First, as our wellness PSA, if you, another State Bar member, or a law student you know is struggling with drug, alcohol problems, depression, anxiety, overwhelming stress, or other medical conditions that may affect competency, then help is available. Please contact Lawyers Concerned for Lawyers, LCL, a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with LCL is strictly confidential and privileged. You can also call 988 to reach a mental health professional or an all-one health employee assistance program, formerly known as Sand Creek, at their confidential crisis telephone line of 1-888-243-5744. Mental health professionals at both numbers are available 24 hours a day, 7 days a week. During the conference, All One Health will have a booth in the registration area as available for more information. Second, this year marks 125 years of the University of South Dakota Knudson School of Law. The law school invites you to join in the celebration of this milestone by attending the Grand Gala, which will bring together alumni, friends, students, faculty, and staff to reflect on the last 125 years and look ahead to the future. The gala will be held on Friday, June 26th. A hosted social hour will begin at 5 p.m. with the dinner and programming to follow. Semi-formal attire is suggested. You can purchase tickets at the USD Law table outside this room. Also, don't forget to network between the CLEs. We will have fresh popcorn, sweet treats, and refreshments available after each of the programs this morning and this afternoon. We'll check that out in the back there. Finally, please make sure to provide feedback both on the State Bar Association as a whole with the QR code up there and with CLE programming. Please take a few minutes to complete the brief survey at the end of each session and let us know to engage with the State Bar as to how we can best meet your needs. Those who complete the survey and wish to enter will be entered into a raffle for an Amazon gift card. With that, today's program is scheduled to last approximately 55 minutes. We'll be done with enough time to transition to the next one. And with that, I'm going to turn it over to Mandy Miller and our panelists for today's first group. Thank you so much.
Good morning, everyone. I thought we'd start with a quick roadmap of today. Your first program today is going to be a panel of individuals that are involved in the mental health field. We're going to talk about the involuntary commitment process as well as representing individuals with mental illness or capacity concerns. The second panel will move into medical professionals that will talk about working with individuals struggling with mental illness and capacity concerns. And then the third portion of our program today will be talking about elder abuse, capacity concerns, and we'll have some resources available for you with both our Medicaid Fraud Control Unit in South Dakota as well as consumer protection to talk about scams and different things that happen when we're dealing with a either older or incapacitated population. For those of you that don't know me, my name's Mandy Miller. I'm with the Attorney General's office, but mental health law has always been near and dear to my heart. I started out as a law enforcement officer where I was regularly involved with the involuntary commitment process. After that, I went on to become a mental health therapist. I did in-home family and child therapy. I was also a licensed foster parent and ran a therapeutic foster home before deciding to go to law school. My first position in my legal career is now the one that Mr. Wilka holds, and that's as General Counsel for the Human Services Center. So we're here to talk about some important and sometimes confusing issues when it comes to our mentally ill and incapacitated populations. With that, I'm going to turn it over to the panel so each individual can introduce themselves.
Hello. It does work. Hi. My name is Tara Walton. I'm with the Sioux Falls Police Department. I'm the supervisor for the Community Resource Division. In addition to that, I am the Crisis Intervention Team Coordinator, which we'll talk a little bit more about as we go this morning. I also lead our peer support team, which basically helps officers get through critical incidents and any personal issues that they might have. And then I also am involved with the mobile crisis team, which I think we'll get into that a little bit as well, and handle all the mental illness cases basically that come our way within the police department. So I take a look at cases where there's been holds, and then I also get information from officers. So if we have an individual that has been repeatedly calling, we have a lot of calls for service, I am able to connect with a mental health therapist through Southeastern Behavioral Health, and we go out and we do outreach to try to connect those individuals. So pretty heavy into the mental health side. Prior to my law enforcement experience, I was a therapist as well, so have a little bit of that going into this. Thank you.
My name is Rochelle Norberg. I'm a private solo practitioner from Burke, South Dakota. I currently serve as the County Board of Mental Health chairperson for Bennett, Gregory, Tripp, Todd, Jones, and Millette counties, so 6 counties in the Southern 6th Circuit. I've been serving, starting as an alternate in 2019, and have been serving as chair for all 6 of those counties for the past 5 years.
Good morning. My name is David Wheeler. I'm a circuit court judge in the 3rd Circuit. Before coming on the bench last year, I was in private practice for around 19 years. For several of those years, I was the county board chair, mental illness board chair for Beadle, Hand, and Kingsbury County, and then also served in state legislature for 5 years and was involved in legislation involving the competency process.
Good morning. My name is Andrew Wilka. As Mandy indicated, I am General Counsel for the Human Services Center down in Yankton. Before that, I spent 8 years as General Counsel for a small financial company in Sioux Falls, and 5 years before that as General Practitioner here in Minnehaha. More important probably than my background is a little bit of background on HSC. We are the only state-funded psychiatric hospital in South Dakota. We provide 5 key corridors of treatment: adult acute program, an adolescent acute program, our substance abuse program, the inpatient psychiatric rehabilitation. Most of that will be with the restoration programs that plenty of you, I'm sure, have questions about or participate through your clients. And then our licensed geriatric program, which is a geriatric psychiatric facility that is separately licensed. HSC fields most or a lot of the questions I feel the bar has, which I think is appropriate for this topic because we treat the most extreme of cases. That is what our patient clientele is the ones who can't find treatment within the communities, within the outreach programs, they end up with us. We also take all of the NGRI patients who get the not guilty by reason of insanity acquittal. They come, if they need additional treatment, they come to our facility. Thank you.
So I figure we'll kick this morning off with probably the most urgent question of the morning. Officer Walton, if someone's experiencing an emergency mental health crisis, what course of action should be taken?
If there's an immediate crisis, you need to look at safety, obviously. Anytime that there is a threat to life, that's going to be an emergency. If the person is threatening to harm themselves, well, threatening to kill themselves, we'll just flat out say that, or if they've done something to themselves that leads to a medical emergency, that's when you're going to want to call 911, get law enforcement, get paramedics, get those people rolling. But when we talk about that immediate crisis, it's going to be someone that is right at that verge of basically life or death. Are they contemplating suicide? Or is it just a mental health crisis in general due to a mental illness, and things have progressed to the point that they have become a danger to themselves for some reason, whether through actions or emissions, or are they a danger to someone else?
And Officer Walton, can you provide just some concrete examples from your experiences to kind of highlight those differences?
So I think, when we talk about that threat, we can all imagine what would be a medical emergency, right? The obvious ones are going to be, someone has taken more of a substance than what is prescribed. By definition, that's an overdose. So if we have that going, we obviously need to get medical going. If we have someone that has maybe cut themselves or done burning or something like that, where it is so deep that they need that medical attention or their life is in danger, those are pretty obvious reasons that you would want to get immediate help. But it doesn't necessarily have to be an action. You could have someone that is, whether it's verbal, whether it's digital, they're texting someone, posting something. If they are immediately, or if they are talking about suicide, that's going to be an emergency. We just don't know if that person obviously is planning to follow through or not, but leave that to the people that are responding to try to determine if you're hearing those words that they're going to kill themselves or sometimes indirectly. Go ahead and get 911 called, get that emergency response started so we can assess that situation. The other emergencies we don't necessarily think of right away are those acts of omissions, things that people are not doing that puts their life in danger. So sometimes we will see someone that maybe is no longer eating, no longer taking care of themselves, not drinking water, and they're just to the point that maybe they're not even mobile anymore. They've just been very lethargic. That also can be a threat to themselves and be an immediate emergency situation.
And Officer Walton, it's my understanding that some law enforcement officers have specialized training to respond to emergency mental health situations. Would you talk about CIT officers and mobile crisis teams?
Certainly. So maybe you've heard of a CIT officer, maybe not. It's actually an international program. It began in 1989 out of Memphis, Tennessee. It was a program that was developed through the National Alliance on Mental Illness, Psychiatric Institute, the university, and the police department. It started in 1989, eventually has rolled across the country and around the world. What it is, it's a 40-hour course that certified law enforcement take. It is intensive. It teaches them about de-escalation skills. They learn from experts in the mental health field, legal advisors. They hear from people with lived experience. And what those officers learn in that 40 hours is, how do I recognize when someone's in crisis, whether it's due to a mental illness or a situation? How do I recognize that? And how can I work at de-escalating that? And they learn methods for verbal de-escalation. Obviously, safety is still first and foremost, but they just learn about medications, calming effects, resources in their own community. Where can I refer these people to? And the point of the program is not only the de-escalation, but get people referred to where they need to go, keep people out of the criminal justice system. It's a cost savings. If a CIT officer can handle a situation on scene and not have to progress to the mental hold side, that's going to be a savings to the county, potentially to that individual as well. And what probably is the most interesting, at least for me because of the law enforcement side, is departments that have these programs statistically have an 80% decrease in use of force situations. So that's a huge safety. It's not only for the officers, but it's also for the individuals we're dealing with, for their families, and anyone related in the situation.
So, Officer Walton, if a CIT officer or a mobile crisis team responds to a medical emergency, what options are available to them in handling the situation?
Obviously, if it's a medical situation, the whole mobile crisis team is off the table. We're not going to just try to verbally de-escalate someone. We're going to get them that medical attention, and then proceed from there. If we're not talking about a life or death or a medical concern, what's going to happen with that CIT officer or mobile crisis? and they are protected under the same statute. What they're going to do is just try to work with that person, de-escalate, refer to services, develop a safety plan to obviously just try to keep that person home. We know it's more humane for that individual if they're able to stay in their home, not being taken away from their families, not having to miss work the next day. Quite often we see that financial burdens can be part of what is leading to that crisis, and taking that person away from their job, potentially losing that job, having another hospital bill, that's just compounding those problems. So obviously, if we need to take someone to the hospital to save their life, we will do that. But quite often, we are seeing some of those, you could almost call them social crises. It's in the moment, I'm making a statement, I didn't truly mean it, maybe there was a substance on board. But if we can work at just working with that individual, the family, and come up with a plan to leave that person at home with some follow-up, that just can be so much more beneficial and humane for that individual. Plus, they're much more likely to call law enforcement again in the future when they're having that type of problem.
Thank you. If a county or city has an interest in CIT-trained officers or starting a mobile crisis team, who can they contact?
I would recommend, if it's law enforcement, contact the Law Enforcement Training Center in Pierre. Whenever we offer a course, we do advertise through their system so they can easily see when we do have that program. As far as a mobile crisis team goes, I would recommend getting in contact with your local community mental health agency to try to start that process. We do have one here in Minnehaha County that's a mobile crisis team. We have that in Minnehaha and Lincoln, and then Hughes and Stanley are the only other two counties in the state that have mobile crisis teams as well. And basically what those are is they're groups of mental health professionals. They operate out of a community mental health service paid for by the county, but they will respond on law enforcement's request to come out and work with that individual where they are. It could be, and I've seen this, it can be in their home, it can be at work at McDonald's, it can be in a park. Some of these individuals are unhoused, so it might be that they meet right there in the patrol car. So mobile crisis teams are great. They connect people with resources. They bring the mental health professional right to the scene, can help avoid that whole mental hold process again. It's a savings. We try to keep these people from just revolving through the system. But get together with Community Mental Health Agency as far as the mobile crisis team goes, just to get that ball rolling.
And Officer Walden, regardless of whether law enforcement is CIT trained or not, what is law enforcement's role in responding to an emergency mental health crisis?
First and foremost, safety again. We want to make sure that if life is in danger, we get that person that assistance right away, that medical care. That's going to be our first response. And then from there, the officer is going to determine, is this person a danger to themselves or somebody else? Because if they are, we need to be considering a hold, the mobile crisis team, whatever we need to do to ensure that safety.
And when you talk about a hold, can you explain that?
Yeah. So in our state, if a certified law enforcement officer determines that a person is a danger to themselves, they're a danger to someone else, they have that inability to care for themselves, a law enforcement officer can take that person into custody and transport them to a location where they can be assessed by a qualified mental health professional or QMHP.
And Ms. Norberg, that's where we're going to pick up with you, because I think that's probably the next logical step in the process. If there's not an emergency or law enforcement involvement, can you tell us about the ordinary petition process if a law enforcement officer isn't bringing someone and walking them through that?
Sure. So in South Dakota, in addition to a law enforcement officer being able to initiate a hold, a medical provider also is able to do that. And then you have the petition process. So a petition is signed by anyone over the age of 18 that has personal knowledge of events and facts related to the person that is alleged to need mental illness care. So it's most common for me to see that be a family member, but it can also be a friend, a social worker, or a mental health provider or counselor. The next part of that petition, I guess, it comes to the County Board of Mental Illness chairperson. Some counties may get those directly as a chairperson. There are also several counties that if you have someone that is presenting a petition that is not involving law enforcement, that it is also submitted through the local clerk of court's office for your county. And then the clerk will present it to your board chair for review.
And then once the board chair receives that petition, can you tell us about that process? What's the standard?
Sure. So I didn't think anybody really wanted to hear me talk, Eric, so I'm trying to I'll hold it up. So as a board chair, when you're looking at those petitions, you are looking to see, does this person have a severe mental illness? Due to the fact of that illness, are they a danger to themselves or to another person? Or do they have a chronic disability? And is that person in need of and likely to benefit from treatment? And so as a board chair, you're evaluating that. You also have an immediacy component to it. So as a board chair, if I'm reviewing a petition and Judge Wheeler submits that to me, but the information included in it and the circumstances that are listed are from 2 weeks ago, as a board chair, that is not under statute immediate to the point that I grant a 24-hour hold to have that person taken into custody and evaluated by a QMHP.
And Ms. Norberg, when you say QMHP, can you describe that?
Yeah. So a QMHP is a qualified mental health professional. It is a designation given to either an advanced provider like a certified nurse practitioner or a physician assistant or an MD that has taken specific training through the Department of Social Services and is eligible to be able to evaluate those circumstances and patients to determine if they would benefit from additional treatment or need to be released from detention.
And what happens if the QMHP determines that a hold should continue?
If a QMHP determines a hold should continue, they will present a certification report to the board chair of that county. And as a county board chair, I then review that report and I'm authorized to sign an order for continued detention. And for many counties in South Dakota, it also includes a transportation component that authorizes the patient to be transported to an inpatient facility such as the Human Service Center in Yankton or Monument Health in Rapid City or St. Luke's in Aberdeen are the facilities that are most commonly transported to.
And Ms. Norberg, I'm sure a lot of law offices get calls about this. Is there anybody who can help with the process of filing a petition with the County Mental Health Board?
There are. It is not the county board chair. In statute, the state's attorney is actually authorized to assist with completing a petition. My experience as a mental illness board chair is that many state's attorneys aren't involved with the petition process. I would say a lot of that is related to the fact they often do have a law enforcement component to it, that they're not trying to submit a petition themselves. But state's attorney by statute, if that's not really the case, many board chairs provide sample forms to their local clerk of court's offices so that they're available for the public dealing with a situation outside of law enforcement involvement. There also are, I believe, many of the counseling service centers in the state. For my area, that's Southern Plains Behavioral Health Service, that they also will assist with petitioning processes for individuals that are clients of that facility.
So if a law office gets a phone call, whether it's a client or a family member, and they're calling on behalf of that person to kind of figure out the process and how to advise that family, would your advice to them be either to point them to the local state's attorney or to the community health center?
I would say yes. I would say, depending on population, some of your more populated counties likely are going to be the state's attorney's offices. some of the smaller counties, especially if you've got a state's attorney that's only a part-time position or maybe even a quarter-time position, I would say if you have a local mental health provider, that would be the most logical step.
And Ms. Norberg, just so we know the difference, when we come in contact with people, when they're coming into our offices, it's good for us to know the criteria, right? Because we don't want to damage relationships by starting a process that maybe that person doesn't fall under or qualify for. So could you go over what criteria needs to be met for a mentally ill person to be involuntarily committed?
Yes, I will say that there also is slightly different wording by statute for an adult versus a juvenile. They are very consistent with each other, but there is some slight language differentiation between that, depending if you're dealing with someone over 18 or not. For an adult, the criteria are they have a severe mental illness. Due to that illness, they're a danger to themselves, to another person, or have a chronic disability, and that the person needs and is likely to benefit from additional treatment.
And you said that's a little bit different for a juvenile. Do you know what that difference is?
It would have been smart of me to have the statute up here with me if I was going to say that. I don't off the top of my head. The criteria are very, very similar. There is just a little bit of language differentiation for a juvenile. And if I remember correctly, it's similar to like an emotional disturbance or a mental disturbance versus a mental illness, since some mental illnesses cannot be confirmed as a juvenile.
Gotcha. So when you were talking about a severe mental illness, is there a difference between mental illness, a developmental disability, and people experiencing substance use disorder?
Yes, they are all three, under South Dakota statute, different commitment processes. So that is another piece as a board chair that I see a lot of the time. I have somebody submitting a petition for someone who has chronic alcohol addiction, and they're trying to petition to have that person committed. That is not going to fall under your County Board of Mental Illness. There is a different petitioning process, and the same goes with a developmental disability commitment. They're listed in different sections of the code, and so for purposes of like your county board chair, they are only dealing with mental illness, not with chronic disability or with alcohol or drug-related commitments. But those are also very important things, and things that occur quite frequently across the state as well, and probably are even less known than emergency mental illness commitments.
So let's talk a little bit about those differences in that process. So when we talk about somebody with a developmental disability, we're talking about somebody who has a below 70 IQ, right, that is separate from mental illness, and that occurred before the age of 21. And so when you have that type of situation where somebody is low on the IQ scale and is experiencing difficulties, there is a commitment process for them. And that would, I think the best advice that we could give, and I don't know if you'd agree, would be to contact the Department of Human Services. That there is a separate facility in Redfield, South Dakota, that deals with people who have developmental disabilities. And just as the Human Services Center in Yankton is the only state facility for people with mental illness, the only state facility for people experiencing developmental disabilities would be Redfield in South Dakota. And then, Ms. Norberg, you also brought up another large category of involuntary commitment, and I don't know that a lot of people know that people experiencing substance use disorder can also be involuntarily committed. Can you talk a little bit about the commitment criteria for SUD?
Sure. So under an SUD commitment, You have an intoxicated person or a person that is receiving treatment for withdrawal management, and they may be detained in an approved treatment facility for emergency treatment if they've threatened, attempted, or inflicted harm on themselves or another person, or they're likely to do that if they're not detained, if they're incapacitated by the effects of alcohol or substances that they're taking, or if they're pregnant and abusing drugs or alcohol.
And who would the petition go to? Is there a separate petition for the substance use?
There is, and who that goes to, I would recommend reaching out to your local clerk of court's office. For my particular area, there is another private practice attorney that handles those specific types of SUD commitments within our several county radius. So to me, the local clerk of court's office would be the best place to start of, is there someone that is currently appointed or someone that typically does assist with those types of petitions?
And a good resource for that, if you have a local substance abuse treatment facility, they are also involved in that process and can also receive those petitions. So, Officer Walton, Ms. Norberg, this is for either of you. Going back to the mental health commitments, would you give some concrete examples of someone being a danger to themselves or others? What does that look like? Officer Walden, you kind of talked about suicide attempts and ideations. There's some other behaviors that typically come with mental illness. Can you discuss some of those or some experiences of what you've seen?
So not only do we have those medical emergencies that I had mentioned some examples of, we might have somebody that is in psychosis or is very delusional, and because of those delusions, they're acting in such a way that is putting themselves in danger. So an example I could give is maybe it's someone who thinks their clothing has been washed in poison, and so they choose not to wear their clothing, and then they think their house is bugged, and so they leave their house, and they're not clothed. It's 20 degrees outside. Obviously, this person's not telling us that they're suicidal, but the behaviors that they are exhibiting, compounded with that mental health issue, that would clearly be a danger to themselves. We can't have people doing that in that degree, temperature or being outside like that. So that would be another example that, it's not somebody that's actually, intentionally harmed themselves. It's not somebody posting or telling people that they want to take their own life, but they're actually, behaving in another way that's, really putting their life at risk. That's a very dangerous, situation. Maybe it's somebody that is very manic, and they're choosing in that manic state to not take care of themselves, so they're not eating substances for a week, they're not sleeping, they're not bathing. We know that that can put that person at a risk. And then sometimes we see some of those other behaviors that can go along with that, just, risk-taking behaviors. Maybe now they're getting in a car, and, that's, crossing that line to not only danger to themselves, but danger to the community, danger to others. We can't have somebody that's been up for 4 days straight, super manic, driving around town with their vehicle. That's just putting everyone at danger. So those are a couple of examples that, aren't necessarily those that pop into your head right away when you're thinking about, how's this person a danger to themselves or somebody else. We also can see, sometimes it's in individuals with memory issues. As they age, if the caregiver, sometimes we see that caregiver isn't able or just isn't yet to that point where they're taking care of that person to the degree that they need to be. Maybe that person is getting out of the house now. Maybe it's not temperature-wise where they should be out wandering. Maybe they're wandering into a busy street. Again, these are examples that we don't necessarily think of right away, but it's something as law enforcement that unfortunately we see on a pretty regular basis. I'll
just add really briefly to that, that by far the majority of commitments that I see as a board chair are involving self-harm, but there is an occasional harm or danger to another person. In those particular instances, usually there is also there's multiple things going on. It might very well be that we need to look at a developmental disability commitment type process for that individual on a long-term basis, but for immediate necessity, we're looking at an involuntary commitment as a mental illness perspective because they qualify and it has that immediacy component that something needs to be done and they qualify for that. So I have seen cases involving that with a danger to another person, but I would agree.
Mr. Wilka, we're going to move on over to you. We discussed the County Mental Health Board, that process, the petition process, the evaluation by a qualified mental health professional, and if they determine that the hold is necessary. Can you talk about the process, what happens with that individual next?
Yep. So the first step is to make sure that HSC receives all the proper documentation. So once we get the order for detention, the admissions process, let me back up. For most of our inpatient, the admissions process starts before this hearing. And so during that 5-day hold before they have the hearing, we often have patients in our area or our region or with severe mental illness that can't be housed other places at HSC. So they complete an initial admission, and then after their 5-day hearing, if a continued detention is, and we receive the continued detention order, we place them, if it's an adult, in our adult acute, or if they have substance abuse in our substance abuse program, partnered with our adult acute program. The process is fairly smooth, but there are other, as we noted earlier, there are other facilities. We are a hospital-level psychiatric facility, but there are 3 other private ones that also receive patients, so St. Luke's in Aberdeen, Monument in Rapid City, and Avera in Sioux Falls. So depending on where the patients come from, as well as the locality of where they live, because it's not always the same on where the commitment is. They're committed from counties because they wandered somewhere in a psychosis or cities away. We'll try to get them at the proper hospital to ensure that they're near to their communities, because that's where they're going to get the most benefit from. But the process, once we get an order of detention for HSC specifically, we put them in their treatment, the proper treatment unit, and they start treatment immediately. And treatment differs on each patient because it depends on how their mental illness is presenting, on the level of need, the level of medication, if they need 2-to-1 treatment, if they're a danger where we have to have two nurses with them at all times, 24 hours in their room with them to prevent them from harming themselves during their episodes, their psychosis episodes. I kind of rambled there a little bit. Did I answer your question?
Yeah, Mr. Wilka, how long is a typical stay at HSC?
So that there isn't a typical stay. It all depends on the patient. It depends on how they're presenting, how long they're presenting, if they're reacting to their medication properly. Our whole priority is to get them to the point to return them to the community. There isn't a required amount of time. There's a maximum amount of time for adults that after that initial hearing. There's a 90-day limit to our treatment before a review hearing is required, and for adolescents, it's 45 days before a review hearing. So we'll see patients who are with us for a day. They get medicated because they were off their medication and they're fine. And then we have patients who are with us for years and some for decades. It's just getting those patients to the level where they can return to their community in a way that they don't pose a danger to themselves or others.
And who pays for the stay at HSC? I know when people are considering whether involuntary commitment is an option for them, cost is always a concern.
Yep. For South Dakota residents, the county of the patient is the payer. And for out-of-state individuals who get committed while they're here, it's the state at large. And then for tribal commitments, that is IHS handles the payment.
What happens if someone's released following their involuntary commitment hearing?
If they're released, HSC goes through our normal discharge, because as I said, a lot of them are already with us. So we make sure that we aren't just opening our doors and having them walk out our hospital. We make sure that there's outreach with their community. There's already established continuum of care for their needs to ensure that if they've had issues with not taking medication, that somebody's checking in, or they know where they need to go or where their appointments are. HSC has an extensive discharge process for all patients, even those who don't get the continued detention.
And then for somebody who's going through this process, whether it's an attorney who has a client who maybe has a family member that's struggling with this, or whether personally we have that involved in our lives, that we're going to have to deal with that, whether it's a family member, a friend, or a loved one. Do you have any tips for folks from HSC who are helping guide others through this process?
Tips during the process, I don't have many. I would say be in touch with your client as well as with HSC. You might be able to help facilitate more better communication within the community or with families or with doctors. But the one tip I'd want to emphasize is don't hesitate to start the process. I feel as an ex-defense attorney, I never want to put my client in a bad situation or make their life worse, and it can be perceived that these holds could be worse for the client. But if you have a client who's in jail and not taking their medication or not getting their medication, you can file the petition to have your client petition for these holds, because the most important thing is to get them treatment and get them, especially if they're not taking their medications, back on their medications as soon as possible. Because the longer they go without them, the harder it is to get them back to that stabilization point. And additionally, the more frequent that they are, the more frequent episodes of non-compliance with their medication requirements, or the more frequently they get on and off them, it makes it so their medication is less effective. Yep, sorry.
No, that's fine. So at this point, we're going to pivot a little bit. We've been talking about the involuntary commitment process, and we're going to move over to representing mentally ill defendants in criminal cases. And we're lucky enough to have Judge Wheeler here with us today to talk about that process. So moving over to Judge Wheeler, let's talk about some terms first. As it applies to representing a mentally ill client, is there a difference between mental illness and incompetence?
Yes, there's a mental illness as a medical diagnosis, involving the DSM, whereas competency is a legal term. It's defined in statute when someone is incompetent. You can be incompetent for multiple reasons. One of them is mental illness. You can also be incompetent due to developmental disability or any other physiological condition, medical condition that renders you incompetent. And I pulled up the statute just to make sure I cite it correctly. The client has to be incompetent to the extent that he is unable to understand the nature and consequences of the proceedings against him or to assist properly in his defense. And of course, there's a lot of legal terms in there and a lot of area for lawyers to debate over, but ultimately what we typically see is someone get an evaluation done, and that evaluation goes through a lot of those factors that can be used by an attorney to help determine whether their client is competent to proceed.
Okay. So, Judge, does having a mental illness, does that automatically make someone incompetent?
No. A lot of people can have a mental illness and still be perfectly competent to proceed. The question is, are they managing that mental illness? If there is medication involved in that mental illness, are they properly taking that medication? And so you can have a lot of clients who have mental illnesses that is not itself a reason to jump into a competency proceeding.
What are some considerations for attorneys when determining whether their client is competent?
So a lot of that comes down to your perception of their ability to understand what's happening. Are they able to have a conversation with you about what's going on? It's not always easy to know whether your client is competent. A lot of the people that attorneys represent don't understand the legal system. They don't understand all the terms we use. That doesn't make them incompetent. They just may not know the legal terms that we use. So competency gets a little deeper than just knowledge. And so as an attorney, you have to educate your client, and if they cannot grasp what's going on, then that's when you start having an idea that maybe there's a competency issue. But can they understand the charge, the basic criminal charge that they're being accused of? Can they understand the process that they're going to be going through? Can they have a conversation with you? Do they respond to your questions in a rational manner? And if you're detecting that these conversations aren't going in a good direction, that they're not being helpful, you have to then kind of make that decision. Is there a question here? Are they just a difficult client, or do they actually have a competency issue? Those are never easy, or I shouldn't say, they're often not easy questions to answer immediately. So you may have to build that up over a few meetings with your client before making a decision that you need to initiate a competency proceedings. Sometimes it's really obvious that they're not competent, but sometimes it's a much closer call.
Judge, what should an attorney do if they believe their client is not competent?
So if you have developed a belief that your client is not competent to proceed, then you do have some ethical obligations to protect that client. And it's not exactly clear where that line becomes, where if you have a client insisting, I want to go in and plead guilty to this crime, especially if it's a misdemeanor. You believe that there's a serious question about their ability to understand what's going on. Well, do you have an obligation to file a competency motion on a misdemeanor and delay that process for months and months? I'm not going to give you an answer to that today because it is a very fact-specific scenario that you're going to have to deal with. But you have an obligation to explore competency and do your best to discuss it, if necessary, with your client, and to the best that they can understand. Do they understand that they have a mental illness or developmental disability or some condition making them that would render them incompetent? Are they willing to do an evaluation? I've had clients who were, they were happy to do an evaluation. So that was easy. Sometimes you have clients who don't want to talk about it at all. And then you have to get into the more contentious situation where you are going to court and then filing a motion to have the competency evaluation ordered.
And I'm going to move this over to Mr. Wilco one more time because you talked about that competency evaluation. Right now, the Human Services Center does competency restoration. What does that process look like? Can you describe that, Mr. Wilka?
Yeah, so we, our restoration of competency group it has its own unit. Typically, we have maybe 12 to 18 individuals in it at any one time. That's the amount of staffing we have available to provide that service. And they have a very routine daily schedule. And it's not just, like the judge said, it's not just knowledge-based. And so we put them through, a workbook that helps them understand and learn the court processes and court words and things that they might not have knowledge of just from not being presented with it in the past. But we also put them through other rehabilitating programs. We make sure that they're getting proper exercise, that they're eating enough, and we have them meet with psychiatric professionals to see if there is medication that they need, that if it is a mental illness issue where they just, once they're properly medicated, things will start clicking a little bit more. It's a process that has pretty standardized daily life for them. It's a workbook that we put them through that we based off of the the psych hospital in Oregon, and then have worked with multiple different multi-state organizations to come to what we feel is the best for our patients. But it's fairly standardized from patient to patient, and it also includes, so I teach a class, or I do at least a half hour, sometimes an hour with them on Wednesdays and Tuesdays, where we do mock trials just to get them in each position so they can better understand what's going in the flow of courtroom and how things work. Additionally, they do outings, and so to help them, again, it's not just to get them to a knowledge level, it's to get them to a level where they have the ability to understand these terms that they haven't been presented enough. So it's helping develop their core life skills as well as often part of their curriculum.
Thank you. Judge Willer, if the competent is or becomes competent after competency restoration, what are the decision-making roles between the attorney and then a mentally ill client when they return?
Sure. So once they returned and they've been declared competent to proceed, then that client still has all the same decision-making roles as any other client. And so the client can only make the decision of what plea to enter. Do you waive jury trial? Do you appeal? Do you testify on your own behalf? Those same core decisions that any client has to make. And then as the attorney, you still, obviously your role is to advise them on those decisions and to help them come to a decision on how to proceed in their case. And it's no different whether they've been restored to competency or not with any client. Once they've been restored, you have to make sure they are able to make those decisions and help them through that process like anybody else. And then you as the attorney still retain your decision-making authority over, what witnesses do you call, what questions do you ask, what motions to file, those strategic decisions that you make as an attorney in consultation with your client.
Okay. And we talked about the competency restoration. If an attorney believes that the client may also have a valid insanity defense or may plead guilty but mentally ill, can these evaluations be combined with the competency evaluation?
Yes, that's not uncommon to have a client go through a complete workup, basically, where the evaluator is looking at both competency and mental illness. I once had a client who I didn't have. I asked for an evaluation for an insanity defense. I didn't have a concern about competency at that point. I knew they had a mental illness, but the person was on the medication. They would go on and off the medication. When they were off the medication, bad things happen. When they're on the medication, they're fine. And so I sent them in to do the evaluation, and a couple months later, when they finally happens and I get it back, the report said this person's not competent. Well, I didn't ask for competency, but we couldn't even do the evaluation. Now we had to go back through competency, go through that process first, either restore them to competency, then I could then do the insanity evaluation, because they couldn't even participate in the insanity evaluation. So it happens a lot where they will be in tandem together, but it's just also a good point to note, competency can come and go during the course of your case. And so you have to be, just because they were competent one day, they go off their meds, next conversation you have with them, they might have no idea what's going on. So always be aware of that. And in those situations, you might be getting into a mental illness, like if they've gone off the meds and are now to the point where can they be a danger to themselves or others, you might be getting into the petition process, or just doing your job as a counselor and getting them connected back with their own mental health professionals.
Thank you for that. So if a defendant, if a defense attorney were to pose those defenses, either not guilty by reason of insanity or guilty but mentally ill, What are the potential outcomes of each of those potential pleas?
Well, in a guilty but mentally ill plea, the outcome is the same as just a guilty plea. They can be sentenced up to the maximum. There's really no difference in the sentencing process other than it comes with a designation that it was a guilty but mentally ill plea or potentially a guilty but mentally ill finding by a jury. With a not guilty by reason of insanity, if you are successful in getting such a verdict from a jury, your client doesn't walk away. If that's the verdict, then they actually get held, and then they will be evaluated by HSC, and then a determination made whether they're a danger to self or others.
And Andrew, Mr. Wilka, I'm going to turn it over to you to close. What occurs at HSC when a defendant is turned over to HSC after a not guilty by reason of insanity verdict?
So if an NGRI verdict is provided for a patient, first it's a medical treatment from our perspective. They are acquitted, except for they have a conditional release. They have a need to be able to prove, it's up to defense to prove at these hearings that they don't pose the risk to society or to property. And so we put them through a psychiatric treatment. We put them through life skills training. They have their own unit as well for just NGRI patients where they're receiving daily treatment, daily exercise, a daily curriculum to try to get them to a point where we can return this individual to society from our best perspective. And that's our entire goal. This can sometimes be frustrating to courts as well as to attorneys because if with an NGRI, we could give them 2 weeks of treatment and find them that they've been now in a position where they can be released. But from our perspective, it is an acquittal. And so what we do then is we present a certification to the judge that provided that verdict, that we certify they are recovered and we don't believe them to be a danger. And then there's a hearing, and it's ultimately the judge's determination on whether they agree that certification is accurate. But part of that comes with a report from our psychiatrist or psychologist who meets with them routinely and gives a very detailed mental health report and projections on whether they think there will be a danger in the future or what their risks are, what we need to look out for, what sorts of foundational community assistance that they are going to require to make sure and to ensure that they are not going to be back in this situation. But with everything from our perspective, we can't guarantee results. So we are saying in their current state, with this current plan and discharge plan, we believe they will be successful. But if they go off that plan, then oftentimes they won't be successful. One thing I'd like to emphasize, this isn't really part of your question, but it's up to the state's attorney who is responsible for monitoring NGRIs once they're released to ensure that they're complying with whatever discharge plan, to ensure that if they're placed in a less restrictive means and some outpatient, there's plenty of mental illness facilities that provide easiest way to describe them would be like a halfway house for substance abuse. It's a less restrictive, non-confining facility for mental illness where they can get some help and participate in society at a higher level than they would at HSC. And it's up to the state's attorney to determine and communicate with those facilities to make sure that they are followed with. We get frustration that we're not overseeing. Once patients leave our doors, unless we're providing specific outpatient treatment, we have no oversight or control over those individuals.
Thank you for that, Mr. Wilka. As we close out, I do want to note we have up on the screen the publication put out by the Unified Judicial System on the Defense Attorney Guide to Representing a Client with Mental Illness. This is available in your materials. It's also on the UJS website. It's a good publication to look through if you have somebody with mental illness. Also at the back of it, there's some very helpful forms for competency evaluations, NGRIs, and guilty but mentally ill. Judge Wheeler?
Yes, one point that I wanted to make about evaluations that I forgot. It's important to make sure you know that during an evaluation, your client may discuss the facts of the case. And so you're going to be careful about that and what that may reveal, who's going to get that report. And that depends on who ordered the report. Was it the prosecution? Was it the judge? And so you might need to decide, if you're on the defense side, do I need to ask for a consulting expert so that way I only get the report and then I decide if I'm going to then file that and proceed with competency or an insanity defense. Be strategic about that so you make sure you're not handling and revealing client confidences and potentially damaging your client's case in the process of a competency or an insanity evaluation.
Very good tip. Thanks for pointing that out. As we close, are there any questions? All right, it looks good. I think we're ready to move on to our next panel. Thank you.
All right, everybody, we're going to get started here in just a second on our second hour as we continue on with our CLE program, Working Together, Client Capacity Concerns. The second hour focus is on ethical and practical considerations with diminished capacity. As a reminder, my name is Eric Hansen with the State Bar CLE Committee. I'm going to briefly go through just our PSA reminders. If you have further questions, please let me know. As always, we have assistance from Lawyers Concerned for Lawyers, as well as all One Health employees are available as well for discussing any resources. If you're interested in the 125th Grand Gala for the USD Law School, check outside the USD booth out there. The tickets are still available. Make sure that you network, grab snacks, drinks, things like that in between. As we're going to rush into this next one, please complete the survey that goes along with it. And finally, for this particular group, I want to stress one portion with it. We have a great group available for this panel that represents both the legal and the medical profession. They are going to get into areas that talk about not only potential for legal advice or medical advice that goes in with it. What they're talking about is in the general sense that goes in. Nothing that's provided today is a specific amount of legal or medical guidance. Please make sure for you and your clients that they're seeking specific guidance that goes along with it and that they're getting that advice and that evaluation. And with that, I'm going to turn it over to our group.
So thank you, and good morning. Today we have a great group here, like Eric said. We're going to talk about ethical and practical considerations with diminished capacity clients. Before I let our group introduce themselves, we just heard about when the state steps in. So if we remember back to like law school year one, the state has that police power where she can step in and take away some of the rights of the individuals for the sake of their safety or public safety, or maybe a parent's patria where the state steps in to be a parent, and this is how she does that. We are going to talk about you with your client when you start noticing diminished capacity or you're creating documents that accommodate their diminished capacity. And so no longer state stepping in with an authority, but how can you help your
client prepare for diminished capacity. To start, I'll just turn it over to my panel to introduce themselves.
Can you hear me? Good morning, everyone. My name is Dr. Amanda Solachek. I am board certified in internal and palliative medicine. I am practicing in Yankton, South Dakota. My practice is outpatient.
Good morning, Sarah Molman. I'm the nurse on the panel, so really looking at how does everything that you create with your clients affect us at the bedside. And I work for SDSU College of Nursing.
Good morning. I'm Michelle Snyders. I'm the clinical social worker on the panel, and I am the current hospice and palliative care coordinator for Sadajo's Life Circle, South Dakota's Hospice and Palliative Care Network.
Thank you. And I'm the lawyer on the panel, so in private practice estate planning for years now on the trust side of this world with the administration. But estate planning, when you're either drafting or administering, touches in a small sliver some of those ethical decision-making on both healthcare and law. With that, I'm also your elder law chair, so if you have issues that you're like, oh, I wish the elder law would do something about this, please let me know. And then I do have a couple adjunct appointments where I get into law and bioethics, so a master's in bioethics, which is just a really fun place to kind of delve into these ethical issues. So to start, I want to say, remember back to 8th grade, right? I took you back to first year law school, now go back to 8th grade government. We, as a people in this country, have a right to life, liberty, property, pursuit of happiness, and with that right comes this right to autonomy, right to make those decisions. So there's lots of material out there about, do disabled people have capacity to create a will? So we talked to the panel before us talked a little bit about IQ levels. We want to stress that capacity is presumed. So until something happens or a state steps in and narrows it, capacity is a right of all individuals. Then we're also going to propose that instead of asking, does my client have the capacity to do, or does my client have capacity to, we're going to recommend a different set of questions. Have I given sufficient information to my client to make this very task-specific decision? Have they received, understood, and evaluated that information that I gave them? And then were they able to make a choice that was voluntary and communicated to me? So those, instead of just, is this capacity diminished? Breaking that into these 3 parts. We'll do that by going through 3 steps. First, competency versus capacity, informed consent, and then 5 steps for you to think about when you're drafting documents. So first of all, competency versus capacity. Several states will use different terms: legal capacity, competency, clinical competency. In our state, I'll argue, and I think we heard it from our panel here too, but competency is something that is determined in a court, right? So to remove competency is a court decision. A judge is involved. Capacity is something that a physician is going to look at, task-specific. Do they have the capacity to do a certain task? So competency refers to a state of being generally. Capacity refers to the task-specific ability of a person. Since we already talked about competency at the previous panel, we're not going to discuss that. We're just going to talk about capacity. As with all good, tough, complex issues, there's usually some battling going on, especially in healthcare on some of these ethical issues. And that battle is more easily fought when we have good definitions and we all agree on those definitions. So just for fun, I'm going to give you a word so you can all fight over the definition, but Just kidding, don't get any brawls here. That word, I want you to just define it in your mind. Embryo. So did you go with human life, mass of tissue, right? The definition of that word is still causing issues, right? If we go with human life, now we have legal protections, treat them as a person. If we go with mass of tissue, now we have research possibilities in cloning. So the paths that we go down often stem from a very clear understanding of a common definition. So in law and in healthcare, I think we find a common definition and with capacity. So we'll start with that. If we look at capacity, that in healthcare, so that first statute is our South Dakota MOST statute. Decision-making capacity is the ability to understand to a reasonable extent this information that is given, right? And then communicating a choice. So we have three elements that we're starting to see. Information given, understanding of the information, and communicating that choice. We have that same three elements, I would argue, in that next statute, which is our agency statute, in particular for financial powers of attorney, where incapacity is the inability to manage property, business, or finances because they have an impairment or deficit in the ability to receive that information and make that decision, right? So again, we have information that's going to be received, then evaluating it and making a decision about it, communicating that decision. We're gonna come back to this A and B in this statute, so just note that incapacity can be either determined by A or B. We'll come back to that in a minute. But hopefully, right, across both our MOST statute and our agency statute, we're seeing that same three elements. Then another Healthcare Consent Act statute, where if a person is incapacitated, a surrogate steps in and makes a decision for them. Incapacitated person is anyone who's incapable of giving informed consent. So hopefully our statutes line up and informed consent looks somewhat like capacity, but let's look at those elements across healthcare and law. So informed consent in healthcare, probably if you've all at some point been to the doctor, you know what that looks like. We have this consent voluntarily and knowingly and competently given without any force, fraud, deceit, after a conscientious explanation of all information that the reasonable person would consider significant. And then we have this decision made, but that decision has to be comprehensible. So, and then in addition to our statute, we just add, we often see, and our ladies here can confirm that, but that speaking about the risks involved and the available alternatives is also necessary to that informed consent process. So once again, same three elements of informed consent we see that we just saw with capacity, right? So what's the purpose of this? When you walk away and you say, how do I determine if my client has capacity? You're actually asking, how do I inform consent my client? Have I done that well? So we just showed you healthcare. Let's turn over to the legal side. Our rules of professional conduct, they say we shall, not may or could if we want to, but we shall promptly inform our client of any decisions that require informed consent. So informed consent, we're gonna see in that Rule 1.0E, and it looks very similar to our healthcare statute. We have this agreement after adequate information and explanation about the material risks and alternative, reasonable alternatives have been given. And then in order to have an agreement, I just threw in Black's Law Dictionary there. For an agreement, we require understanding and assent. So again, information given, consent takes place, but in the middle of that, there's an understanding process that happens. So when we look at capacity, again, we're not asking, does my client have capacity? Capacity is presumed. Is their capacity diminishing? Instead of asking that, we would propose that you say, do they have the ability to give me informed consent on this very specific issue? That information is going to be task specific and person specific, IQ specific, right? Maybe even time specific. In the morning when they're awake and alert might be very different than giving them information after a long day. We know how to capture the information. We've got good guidance on you need a notary, you need 2 witnesses. So the tough issue is how do we understand or measure if our clients are understanding, receiving, evaluating those risks and options before they make their decision. For this, I'll turn it over to Dr. Amanda. Can you tell us what this looks like in your practice, how you do this with your patients?
Thank you. So I would share that determining capacity requires evaluation of multiple areas of their lives. And so it's usually not meeting somebody for the first time, being able to fully determine this, but it's looking at their ability to communicate, their ability to walk in the room safely, their ability to participate in their therapies if they're in the hospital. And so largely when I'm evaluating patients for capacity, I have objective tests that I do, but also subjective tests, and I also work alongside a team. And so I'm going to start talking about the objective tests, and some of these you may be familiar with. One test that I use quite often is called the MoCA, also known as the Montreal Cognitive Assessment. This tool is used to evaluate cognitive impairment, and so it'll show if a patient has no cognitive impairment, mild, moderate, or severe. And so different things that we look at are executive function. An example of this would be when I ask them to repeat a sentence after me or repeat a series of numbers. Another test that we will do is a visual spatial skills test. I will ask them to draw a clock with a specific time on it. I would expect proper orientation of numbers and the hands of the clock. The other thing I would do would have them complete a series of, for example, drawing a line from 1 to A, as 2 is to B, and so on, and ask them to complete that. Other portions of this would be assessing like their language. I would ask them to identify as many words as they can think of with the letter F in 1 minute. Memory, I would repeat 5 words to them and then ask them to recall it in about 10 minutes. And the attention working memory would assess it then after that 5 to 10 minutes. And the last piece would be orientation. Are they aware of the location that they're at, the date, time as well? As I shared, this is just one piece, the very interactive piece, but I think having a good feel of their past medical history is vitally important. Looking at any brain imaging they may have for any atrophy or age-related changes. Any history of having a stroke or a brain mass is especially important. Other things, as you may have heard in the previous lecture in regards to medications, I need to make sure that they're metabolically clearing medicines. And so for whatever reason, if they're in acute kidney failure or acute kidney injury, if they're dehydrated, that can affect the metabolization of medicine and cause changes in cognition. Also important to note, we look at the acute processes going on in their lives. If there is something where a patient has like a urinary tract infection and develops sepsis, it commonly causes confusion. Important to note that, as they mentioned before, that capacity can also wax and wane. And so if we are in an acute process, we try to make sure that is resolved before we fully determine capacity. And so this is the more intricate part, just kind of like the skills that we develop over time with our subjective analysis. And so as I share, and similar to you, when you're meeting with a client, when I'm meeting with a patient, I'm seeing like, are we able to carry a conversation that's linear? Is everything making sense? Are they able to voice, what have the physicians told me about my past medical history? Where am I at today? And what does my recovery look like? That helps me determine if they understand the risks versus benefits of the treatments that we're talking about. As we share, this also includes just subjective, like watching them walk into the office. Like, are they aware of their surroundings? Are they tripping and falling? Are they using appropriate assistive devices? Did they bring anybody with them? That is a unique part in medicine. Commonly, when we're doing the subjective analysis, there will be other family members and team members present. Important to note, when I'm doing the MOCA, I do it with the patient alone, but this subjective part is typically with other team members. And so team members commonly include myself, my nursing staff, our social worker. It will also include the various therapies that are working with them. And if I'm in a place where the data isn't making sense, I will also include a second physician in there when we're having these conversations. And so I love this slide, but it is the most challenging part of what we do. As we know that there are different levels of capacity, there can be simple ones where people are able to say yes versus no, but then they may not be able to explain why. And so I think, like as we've discussed, like the capacity, it varies based upon situation, it varies based upon like their past medical history and what's acutely going on, and this can be really challenging. I feel like, as you can tell, I predominantly focus on the medical portion of things. So very often we're able to have patients ample a simple question like, am I okay getting lab work today? Am I okay getting a CT scan? But they maybe not be able to explain why or how that impacts treatment, whether they're gonna get chemotherapy or radiation. They may not be able to voice that. But if a patient is able to consistently tell me that, no, I don't want the CAT scan, no, I'm not going in there, despite the reason for that, we do try to honor that as best as we can.
Yeah, thank you, doctor. So I like what you said about, this is a medical assessment. You're giving medical information, you're talking about medical risks, medical options, and then assessing whether the patient can give consent to the information that you have provided. That's a key piece of capacity determinations. We're going to dive into that a little bit more. With that, our statute allows you, if a healthcare power of attorney is created and it springs in and out of action, or if it's, I don't know if people create healthcare powers of attorney that are effective immediately, but you as the attending physician retain the power to tell the agent, nope, patient still has capacity. Despite what your legal document says, patient still gets to make their decisions. Do you ever have to get in fights with agents over that?
Yes, I would share, especially for my patients that have like dementia or they have an acute process that's going on. An example of this would be, I have a patient that's acutely ill in the hospital. They are encephalopathic and confused. We are presuming that it's related to an infection, but there is question on whether or not they've had a stroke, and they would recommend getting a CAT scan to further evaluate it. In those instances, I have had patients that have absolutely refused to do that, and the patient's family member, or sorry, their durable power of attorney would be like, nope, I want all aggressive measures done, we're gonna do this. And in order to do that, we're gonna sedate this patient, we're gonna take them there to get this done, and then we're gonna wait for the medication to wear off to reassess, like mentation. And so, like I share, as a physician, if a patient is like gritting and yelling and saying no, and they've done it repeatedly for me and for other healthcare members, we will honor that patient's wishes.
Thank you. So I'm gonna go a little further. Our statutes for durable power of attorney for finances say that we can either have them be effective immediately or create this triggering event or contingency and place a person in charge to determine if that contingency has happened. If the document doesn't do that, then this part in red says that when the principal becomes incapacitated, then the physician or licensed psychologist will, so the triggering point is incapacity, and the physician or licensed psychologist determines incapacity. In light of what we just talked about how you determine capacity, and you're talking about health benefits and risks, is this a easy place for you to determine incapacity about benefits and risks of financial decisions?
So I would share that I have not been trained in any financial evaluation for our patients. I wouldn't even know where to begin with this in terms of asking those questions. I would share the other challenging piece of this is we know that finances are pretty intricate with like healthcare and capacity and all these things. we are clearly directed by like our healthcare teams that we are not able to comment on finances. Like, for example, if a patient comes into the hospital and they want to complete advanced care directives, we are only allowed to do a medical power of attorney and a medical living will. We are not allowed to complete financial power of attorney documents in our offices.
And if a financial agent came and said, hey, I think mom doesn't have capacity to make this decision, can you, trigger this financial power of attorney for me? Would you feel comfortable doing that?
I have been asked to do this several times, and I feel like I am not capable of because I don't have the training, I don't have the documentation, and lastly, our facilities and our attorney tell us that we are not able to do this.
So maybe that's not a big deal, because then next in blue, our attorney, a judge, or an appropriate government official can also trigger that incapacity. But if we look back at section 591215A and B, notice that the physician under A is determining whether there's an impairment or deficit, and the attorney under B is only determining incapacity in the sense that the person's missing or disappeared or detained or outside of the United States. So in our statute, there's no permission for attorneys to determine a mental incapacity. I think significant just to point out that hole. So I have a case study for you, doctor. Thank you for your letting me ask you all these questions. Your patient, Bob, starting to show signs of diminished capacity, and you now look to the healthcare agent, Bob's daughter, to make healthcare decisions. You get a call from the agent under the financial power of attorney, Bob's son, who asks if you can tell him whether dad has capacity. He prefers it in writing before he signs off on the sale of dad's house.
So thank you. This is also a common question that we get. And so several challenges with this. So first of all, if I do not have the appropriate paperwork that I can release information to a son, I cannot do that. So that's violating HIPAA. So if I do not have a release of information, I cannot do that. Lastly, like I share, if he is the financial power of attorney and not the healthcare power of attorney, I'm not able to enter into this either for several reasons. Several reasons being not able to comment on like the financial part. Two, if I haven't had a previous relationship, I don't know what their relationship looks like and the appropriateness of this. And my duty is to the patient. And so I've had several situations like this, and I've had several situations where my patient was determined to not have capacity, transition to hospice, and pass. And then a month later, the financial power of attorney comes to my office, wants documents saying that the patient didn't have capacity and the things that they did in the last couple of weeks are not accurate and true. Our legal team has told me that my relationship is to the patient only, and once a patient is deceased, I cannot write documents to say at this date they lost capacity and to enter into these disagreements.
So if our financial power of attorney document included some HIPAA language, you mentioned HIPAA and how you can't give personal health information to anyone who's not under HIPAA. It's called a personal representative, which is confusing sometimes for our estate planners. But if the durable power of attorney for finances had the authorized HIPAA information, could you release that health information to them?
I think that ideally they would still have like the healthcare, like durable, like release of information form signed as well. And so that would still be the recommendation that we cross all areas and making sure that they're all signed.
Okay.
And ideally, I'm aware of this person before we start having these conversations.
And I think you had mentioned to me too when we were kind of talking about this that maybe you would give them, the results of the MOCA score, but you're not necessarily giving them your assessment and analysis as a professional as to their capacity under a financial document. So even if the HIPAA language was in there sufficient to release the MOCA score, that financial agent might not even know what to do with it. Would that be accurate?
Absolutely, absolutely.
So again, not legal advice, but take it with a grain of salt. We would propose that maybe you consider in your financial powers of attorney asking your client, how would you want to care for your future incapacitated self, instead of just leaving it to the physician or licensed psychologist to determine incapacity? Is there a different trigger? Is there a different place where your client says, oh, you know what, once I say I can't balance my checkbook, I don't even know if people have checkbooks anymore. I'm looking at the younger kids in the room. Then let my agent take over. Or once I'm in a care facility, so we would propose asking that question, have that conversation with your client. What do you want to happen? What event do you want to trigger? And how do you want us to note that event? So moving on then to creating documents for clients with diminished capacity, we're going to give you 5 steps that hopefully you find useful. The first step is the one we started with, presume capacity. It's both a legal and an ethical matter, but the capacity of all adults is presumed. Whether it's questioned in court or elsewhere, the burdens establishing any diminution is on the party challenging capacity, right? So that burden of proof is important. It's going to fall on the party trying to challenge the presumed capacity of your client. We stole these 5 steps from an ABA article that we created. There is a live link in here. I think you have access to the slides. Just to prove that point, when we look at our statute on wills, and then even the Brosnan case, which was from 1923, US Supreme Court case, it confirms any contestant to the will has the burden of proving that lack of capacity. So, doctor, another case study for you. Bob now passes away. He left everything to his new spouse, whom he married 4 months ago. Just in case you think that's a crazy scenario, you can read this People article. The old will left everything to the 3 kids equally. Now you get a phone call from the son number 2. So remember, son number 1 is the agent under the financial power of attorney. Son number 2 is asking you to testify in court that his dad did not have capacity to make healthcare decisions 6 months ago, and so would also not have had any capacity to create a will that left everything to the new spouse.
I just smile because this happened recently too. Like you share, these are just really difficult conversations and lots of family dynamics and psychosocial pieces that come into play. Unfortunately, we're back into the same place with like the HIPAA, having the appropriate forms and all the things that come into play. When this happens, I automatically involve like our legal team to kind of help guide us on what we're able to comment on. And they usually take over and communicate with the family for me.
So with that, again, you mentioned HIPAA, and there is a 50-year rule in HIPAA that doesn't allow that PHI to go out except for certain certain exceptions, law enforcement, coroner, organ procurement. Son number 2, not one of those exceptions. So what is our point here? When you're planning for your client's future diminished capacity, try to base that planning on something that doesn't rely on a physician's determination of incapacity or their testimony. We think that would be a better planning for your client. Again, specific to your client, make your own decisions, but here at least we're showing you that that's a clunky process.
And like you share, once my patient has passed, my obligation to the patient has also passed. And so, like I share, our legal team had once again told us that once it has happened, that we are not participating in those pieces moving forward.
Yeah, thank you. So step 2, you're asking capacity to do what? Again, task specific, right? So if we look at testamentary capacity, we know that you're looking at whether they have the ability to know the nature and extent of their property, the nature and objects, the natural objects of their property, like who they would normally go to, and the disposition that the will is making. If they're all of a sudden pulling out friend down the street, but you know they have 3 children, that should cause some reflection, right? Contract capacity. In our statute, people are capable of contracting unless they're a minor or of unsound mind or deprived of civil rights. Otherwise, we presume that they have the capacity to contract. I stole this part from the link below, and you can see this is not from our state, but they're using the term mental competence in that that middle portion. So in the real world, both healthcare, I think, with our interactions, and in law, those often get intermixed. But when we talk about determining capacity or competency, we want to keep competency with the courts, and you are determining whether your client has that ability to contract, that capacity to contract, by understanding the nature and the consequence of those transactions. If they're signing a reverse mortgage, but they also think they're leaving their house to their children, well, maybe they don't fully grasp what a reverse mortgage is. And if I ask Dr. Amanda to tell me if, my client has capacity to understand a reverse mortgage, well, she first has to understand, what is this, how is this reverse mortgage going to affect the client? And so we're just dealing with two different languages. Dr. Amanda also went through sort of levels of capacity. I would propose that we, on our legal side, have levels. Creating a will is a lower level of capacity than contracting, right? If you know that I have 3 children and I have a house and I want to leave my house to my 3 children, that could be sufficient to create a will, but you might not understand the extent of your investment portfolio, or how to contract to hire someone to trade stock for you. So depending on the task will depend, similar to healthcare, on what level of capacity our client needs. We would ask you 2 questions because we come across this issue. Where does the capacity to revoke a durable power of attorney for healthcare fall? Do you have to have contract capacity? You need contract capacity to create the power of attorney. Do you need it to revoke the power of attorney? And also to remove an agent. I would propose, only because I'm reiterating what the ABA said, that removing an agent is not necessarily revoking the power of attorney, but is there some lesser level of capacity needed to go from agent 1 to agent 2? Our statute, as you can see, says that a power of attorney terminates when the principal revokes the power of attorney. Some states say when the principal with capacity revokes. Under the VA healthcare power of attorney statutes, the federal law, they say with capacity. They acknowledge or require capacity. In that same statute, 2, an agent's authority terminates. So our statute has separated it into revoking the POA and terminating the agent's authority. Sometimes we have questions about that. Doctor, would it be helpful if when a power of attorney document comes to you, it was clear on whether your patient, or the principal in this case, needs capacity to say, I don't want daughter to make my decisions anymore. I want to flip over to son?
Yes, I feel like any clarity or any conversation that can happen before is super helpful, just so that everybody is kind of aware of this and that we're able just to reiterate it and land on the same page.
Yeah, thank you. So maybe, most documents will say agent 1, unless they're unable or unwilling, then agent 2. Maybe consider talking to your client about, okay, what if you lack capacity? Do you still want to be able to go from agent 1 to agent 2 on your own, and under what circumstances? So we would recommend that conversation with your client as well when you're creating these documents. Step 3, maximize capacity. I'm going to turn it over to Sarah and to Michelle here to talk a little bit about what they do on the healthcare side to maximize patients' capacity, that maybe then we could think of, we could use some of those tools on our side.
Thank you. I think as a nurse, we have the benefit of time. We spend the most time with patients when they're in healthcare. Although lengths of stay are shorter, I worked my career in oncology, so I did get to know patients very well. And I was able to get them alone. Even if a spouse or a family member wanted to be in the room all the time, I'd say, I'm going to take your loved one to the bathroom. Do you want to go get a cup of coffee? then I could ask those difficult questions where they really should be alone when I ask them, safety, abuse, those types of things. But it also goes into, do you agree with everything, your care right now? You know, most of the time I lived in a world where they didn't have any documentation. They didn't have any of these documents. So it was just going down, who's the next person, we'll talk about that a little later, that can make their decisions if they don't have capacity. So getting them alone to ask them those questions, knowing if they have sundowners, when their medications are giving. If we're giving a high dose of pain meds, you want to have those conversations before. Maybe they're more awake and alert in the morning. Space familiar to them, we didn't have that luxury. We try to make space comfortable for them, but we didn't have that. Just being in healthcare in that setting is extremely fear-provoking, uncomfortable. They don't get rest. It is not the space to be making these decisions. Often, though, that is where they're being made. And then just making it all about them. What do they want for quality of life? What does that mean to them? What do they want? And we would get to know that and know them pretty well to be able to know what their personal goals are and their habits and things that they would want to have that quality of life. Anything?
Yeah, the only thing that I would add too is, as we're talking to patients and as you're talking with your clients, it's not about them making a good decision. It's about them making a decision that's appropriate to who they are and their values. So if they can tell me, you know, the reason that they continue to eat chocolate cake when they're diabetic is because, you know, I'm 85 years old and I've lived a good life and this is what's important to me. They've been able to understand the consequences that they're, you know, they may end up with a high blood sugar. They could possibly end up with more complications. If they understand all that and they still want to make a bad decision, that's okay. That's their right. And we don't want to take that right away.
And I think you ladies mentioned too, you know, something as simple as a warm blanket or those comforts kind of from home that just make them feel relaxed in the space can also maximize capacity in that time and in that place.
Yeah, and the other thing that plays into this is their religious preferences as well. So there's certain medical practices that we can't do based on their religion. And the biggest one for where I worked was blood products. We had certain patients that would not accept blood products or any medication derived from blood products. And that was truly necessary to sustain their life while we gave them chemotherapy and radiation. So we had to balance that and work through that family dynamic as well.
Yeah, I like what you're saying here. Even if it's a crazy choice in my mind, a bad choice, you're diabetic, don't eat chocolate cake, or if you don't get blood products, you're going to die. Even though it's a bad choice, it doesn't necessarily mean they don't have capacity to make that choice. So let's go to step 4 then, preparing for incapacity. You, when you're talking to your client, you're creating their estate plan, you're talking about the future. Ask them those specific questions about, how do you want to care for your future incapacitated self? Where do you want to live when you lack capacity to take care of yourself? And then also, we create the powers of attorney as attorneys. Some of those can also be created in healthcare, like Dr. Amanda said. But again, back to our panel here, tell us a little bit about some of the resources that are available for those living arrangements and some of the additional legal documents that come into play at end of life that we don't create as attorneys, but that interplay with the documents we create.
Sure. So, just like Cameo has said about you guys preparing for incapacity, in healthcare we also prepare for incapacity. So if we're working with somebody that we know has a chronic progressive disease, we're also going to be having healthcare-related conversations prior to a crisis. And I think that's what's important for both an attorney and a healthcare professional is do everything you can before a crisis happens, and it makes things much easier on the long term. So some of the things that we would be having available to them would be to talk about resources where they could go. So if I'm having a conversation with somebody and maybe they're more advanced in their disease, and I'm might say, you know, Joe, things seem to be progressing, and I'm a little worried that you might not be able to make some of these decisions later on. So we want to get some things down in our documentation so that we know what to do when you can't make these decisions on your own. So we might talk about, you know, what's the difference between living at home with support services? What's the difference between assisted living? What about long-term care? What does that look like? And trying to give them as much information as possible so they can make that informed decision. So if I forget to tell them something, I haven't really given them informed decision or informed information. So talking about that. Talking about who would you want to make decisions for you when you're no longer able to do that? You know, if we've not been able to determine that a durable power of attorney for healthcare has been created, talking to them about who's their trusted person, who did they go to help support them. That's when I might introduce, how about creating a durable power of attorney for healthcare? Once I have an understanding of what's important to them and who they are, that's when I'll bring in the documentation. Again, going back to what Dr. Solojik said earlier, is that relationship that you build with that person helps you make better decisions with them and not for them. So some of the resources that I would introduce would be things like the Department of Human Services through the state has long-term services and support where they can go through Dakota Abilities, get connected with different resources. So I might be giving that information to family members as well as the patient. Life Circle South Dakota has all kinds of information about how to create forms, what resources are available to support caregivers. So that website is really good. South Dakota's guardianship program, while they don't like to assign a guardian, they are available to help people through the guardianship process, and sometimes will cover the cost of the legal fees, the court fees. So I would refer them to that. Dakota Guardianship and Advocacy is a resource that we have in our state where they actually do appoint guardianship for individuals that may need that down the road, so getting family prepared for that. South Dakota Helpline has great resources, so I might refer patients and families to that to look for very specific things that they might need for their individual situation. And then disease-specific resources like the Alzheimer's Association, the American Cancer Society, all have resources specific to that particular disease. So I would refer somebody to that as well. Resources for powers of attorney and families. One of the things that we have created, Cameo and I, and then a couple other people, we've created some guardianship training videos. We know guardians go through some training on how to fill out the documentation required, but they don't go through training on how do I make these healthcare decisions for somebody that I'm now responsible for. So we've created videos and some worksheets that go along with each of the videos to help people manage those different situations. And I would refer a durable power of attorney who's struggling with that to see some of those videos to help them understand what their role and responsibility is in that particular situation. And then there's conversation guides that are available to patients and families, and I'd encourage you guys to take a look at this too so you can see from a healthcare perspective some of the things that we're tapping into as we're trying to figure out what matters most to that particular person. One of them is called the Conversation Guide, and they have all kinds of different types of documents to help either a patient identify what's important to them, a family member and a patient sitting down talking through, when things get worse for me, this is what I want you to do to help make decisions for me. This is why I want you to do it. So they're really great documents. I always encourage people to fill those out as early as they possibly can when we know, again, that it's a chronic, serious illness, because we never know when something's going to change. Some of the common legal documents that we work with in healthcare, a couple of them we won't go into great detail. You're well familiar with them, and that's the living will and the power of attorney. Although my caveat here with a living will is if a patient comes to me and says, I want to create a document, and they choose a living will, I might talk to them a little bit more about why a living will, and do they have somebody else in their circle of people that they trust that we could actually name as their power of attorney for healthcare rather than a living will? Because a living will only comes into effect when 3 circumstances are met. They have to be imminently dying, they have to have a terminal illness, and they have to be able to no longer communicate. And all three of those things have to be present, and it only applies to life-sustaining treatment. So it doesn't help us make decisions about chemotherapy or blood transfusions or anything like that. So not my favorite document to use in healthcare, but when we're working with those unbefriended patients that we all have experienced, and they truly are the loners in life, then at least we have some type of guidance in the future. So we'll move on and talk about a couple of the other documents that are really important to us in healthcare. And I think it's really important as attorneys that you're aware of these documents. They're not ones you can create. Both of these documents have to be created with a physician, a nurse practitioner, or a physician's assistant. The first one is a Comfort One, and this specifically is a medical order for EMS to withhold life-sustaining treatments. So no chest compressions, no intubation for somebody. So this is appropriate for anybody of any age in any health situation. If they know that if my heart stops and I passed away, please just let me pass away naturally, then a Comfort One would be appropriate for them. The reason that this document is important is it's transportable. So if an ambulance goes to a nursing facility, picks up a patient, and they're designated DNR in the facility, once they walk out that door, that DNR stays in the building. It does not go with them in the ambulance. So with the Comfort One, where the EMTs are getting a physician order that says, en route, if something happens and this person's heart stops, do not intubate and do not resuscitate. Without that order, EMS, the standard of care is to do all things possible to save a person's life. So without that medical order signed by the physician, signed by the patient, or their surrogate decision maker who can fill out this form on behalf of the patient, EMS will provide all things possible. Just a couple things for you to be aware of too with Comfort One. It has to be, the order has to be seen by EMS, so they either have to have a copy of the order or they have to have a bracelet that will act as their identifier, yeah. We're gonna skip quickly to most because that's a more thorough document that we use for somebody that has medical orders. Again, this has to be filled out in conversation with the patient and the physician, and hopefully the identified surrogate decision maker. Has to be signed by the patient and the surrogate decision maker and the physician in order to be a valid legal document. This gives us more information on the type of care that they want to receive, not just life-sustaining treatment, but do they want to go to the ED? Do they want to go to the ICU? Do they want to go to the hospital? Much more information about what's important and the type of care that they want to receive. What else do I? Oh, so if we don't have that, again, the patient's going to receive full aggressive interventions, which might not be the type of health care that they want to receive.
They leave this nice diagram to me. You know, we came together because we felt a real need to help healthcare professionals navigate some of this, and it's in a time where it's all wants to be shared decision-making in healthcare. We want to include the patients and the families, and we actually have this published in South Dakota Medicine for our providers throughout the state to try to give them some guidance. We're always going to start in your left upper corner where they do have capacity, and they need to be making those decisions. I said I often live all the way over to the right where there's no legal document in hand, and they don't have capacity. So I'm going down to their spouse, their adult child, et cetera, and looking at who is that, and does that significant other have legal binding or not? So thinking of, are they an ex? Are they not married yet? Same sex? You know, it's all those things, and it leaves healthcare professionals at the bedside in a sticky situations over and over. We have moral distress because I always say that at the end of every decision is a person. And there's times where we do all this correctly. We have all the documents in place. We know who the durable power of attorney is for healthcare. We know all that. But when reality happens and that person stops breathing, their heart stops, it can go out the window. And I can very well recall a situation where this was truly end of life. It was a terminal cancer. The chances of resuscitating this person and them being okay is less than 5%. We had DNR, we had DNI, and they quit breathing. And that husband said, nope, resuscitate her. And then we had to do it. That kind of thing lives with healthcare professionals for a long time. That respiratory therapist never came back to our floor that I know of. I think she actually left the acute care setting. That's the type of things that we're dealing with and why we are encouraging to have all these conversations as often as you can. But I also, on the flip side, say one of the best things I've ever done as a nurse is walk into a room and tell a patient that they don't have to do everything that the physician is ordering. A lot of people think they have to do whatever the provider is saying. I said, no, you don't have to do that. You have choices. So that's where we really live by wanting to make sure the patient's autonomy is met and their informed consent is met. So this little diagram, hopefully you can have the PowerPoint and you could actually look at this a little closer where you can read it. Really shows what to do. Do they have capacity? If not, do they have a guardian? If they don't have a guardian, do they have a document in place? And then if not, we're over to who's the next relative, or then all the way down to a close friend. And then what happens if they have more than one document in place? And that's where it gets even trickier of what's the most recent one? Is there conflicting decisions within that, and then you're going with the most recent one? I know, Cameo, you wanted to mention something specifically in these, and I would have to put on my glasses to be able to read these. So making sure it helps when you have the durable power of attorney for healthcare be the same person that's in the most. So you don't have conflicting people being able to make decisions based on what document there is. And I know that's one kind of tip that we wanted to bring forward.
Yeah, thank you, Dr. Sarah. With that, so under the most document, which attorneys don't create, a physician, nurse practitioner, physician assistant, and the patient do that together, but it names an authorized representative. And we really want to say, consider in your power of attorney document to say this agent is the authorized representative under the most. If you've thought through the process of naming an agent, then have them continue to retain the power to make these decisions. So here's some sample language, but draft your language, have your conversation that gives the agent the power to act and have priority to act, because there's several actors on the Comfort One, on the DNR, and on that most document. The other thing that I think Michelle said a little bit, but informed consent medical decisions, sometimes we put those in a living will, but then their living will is not used until 20 years later, and it's really not informed for the medical decision that happens 20 years in the future. So just be cautious about the informed consent medical decisions that you put into your documents, and maybe instead appoint the agent, giving them general powers, and encourage your clients to have consistent conversations about what medical decision-making your client, the patient, would want. Otherwise, the document tends to bind the agent, and you might be 20 years in the future. That might not be what the principal wanted at that time. So just asking for a consideration of that as well would be helpful. I know we're out of time here. This step 5 is super quick, but going back to our rules of professional conduct, 1.14 talks about diminished capacity and says that we can take reasonably necessary protective action. What is that? Well, we heard earlier from the panel, seek help from an authority that has the power to protect. Maybe that's the court to appoint a guardian or conservator, the police, you're filing some elder abuse report. Maybe you're reporting unsafe driver and triggers a review by the state. And then just to quickly recap what we said here, ensure that your documents are in place and updated. Clarify what triggers the springing financial power of attorney if it's not effective immediately. Name more than one agent if possible, and clarify if the principal can, revoke one agent and move to the next one. Ensure that the agent has priority in those documents, like Comfort One and most, and then just being cautious about making informed consent medical decisions in your documents that might not be useful till years down the road. Turn it back to Sarah to just conclude us.
Yeah, I think I love this team, and I encourage you to get an interdisciplinary team, bring people together to have these conversations. I think it takes us a little longer, but it's so much more meaningful and impactful to bring people together, because at the end of the day, we're not trying to take people's decision-making away. We're trying to make sure that we preserve their dignity and to support people in making what the best decision is for themselves. And our key takeaway is that capacity is not simply something a person has or does not have. It is something we evaluate through the process of informed decision-making. Time for questions.
Yeah. Questions? Maybe Michelle, will you talk about the forms that you find within the healthcare facilities themselves, not connected to State Bar, but within each facility?
So if you look in statute, there is a South Dakota living will document. Yeah, so that is still available, and that is the one that's utilized. Some of the healthcare systems have incorporated both the living will and the durable power of attorney form together. And then most health systems, because we don't have a statewide durable power of attorney for healthcare that's been approved, most health systems create their own document based on statute, and then that's what's used. Sorry, this is going to be the opinion of Michelle Snyders. They're not very useful other than appointing the person, and again, that's why it's so important to have those conversations and when they're appropriate, to use the documents that help support those individual choices.
And then with that, sometimes, so we mentioned religious preferences and some of the differences there. Sometimes you can find powers of attorney specific to maybe a Jewish preference or Catholic or so.
Specific for dementia.
So if you want us to help you find a form that might be specific to a client, please reach out. Way in the back.
That's a wonderful question. So I want to preface that one of the criteria to qualify for a MOST is that they have to have a prognosis of less than a year. And so those conversations when we're having goals of care, I feel like palliative is commonly having those. If something acutely happens in the hospital where they receive a terminal diagnosis, those conversations are held. But you will see some primary care physicians doing it, and then alongside like their interdisciplinary team with people are starting it, and then the provider leading the case will complete that documentation for it. Good question. Yes, go ahead.
So I'll take the first one because it's really a non-answer, Bobby. I put these resources in here. I think the ACTEC Foundation does a nice job going into that. The Rule 1.14 kind of makes a split of diminished capacity and then. Okay, one of these. Okay, so you know what then? Let me dig into that and see if when they made that split, whenever that happened, I'm like, oh, well, here's some great, useful stuff. And then I looked into it and it wasn't quite as useful. Let me see if I can get something back out to you, but I'm guessing that it's not going to give us really direct guidance. Yeah, maybe the ethics committee can look into that. Oh yeah, that too. I was going to try to pass it off. No, I will look into it and get back to you. Thank you for that question.
So I love her question. She was asking, like, at what point do we consider, like, neuropsych testing? And so I feel like having this relationship with the patient previously really helps knowing, what is their past medical history? Do they have any mood disorders? Is there any bipolar or behavioral things that are coming into play? I would share that neuropsych testing, the biggest challenge is the time it takes to get it. And so usually it's like 3 to 4 months. I would share that locally, like in my Yankton area, very limited, and they typically have to go to Sioux Falls. And so, so for me, when I'm evaluating capacity and I feel like there's some type of behavioral, mental health part that's also affecting it, I will try to reach out to like our Sioux Falls colleagues at like Avera Behavioral Health to see if there's anything they're able to do or if they're able to see them sooner. I will also include ethics in our decision making, just to share that I think this patient is impaired. I'm not entirely sure what we can do to optimize them to help participate, but we do want to continue to involve them as much as we can.
Thank you. We want to get to our other panel, but if there are more questions, please approach us, or you have my contact information through the bar information. Contact me and I can get a hold of these ladies. So thank you very much.
Okay, good morning. We're going to get started with our third part of the program here. Just a reminder again on our wellness and other reminders. If you or any member of the state bar or law student is struggling, please reach out to the Employees Assistance Program, formerly known as Sand Creek, for a crisis telephone line. They're open 24/7. Their number is 1-888-243-5744, or reach out to Becky Porter. The Law School Gala will be tomorrow night. If you've registered for that, there's popcorn and refreshments available in the back, so please help yourself to those. And finally, at the end of this presentation, we'll be putting up on the screen a survey. Really appreciate you guys taking the time to give feedback on all of our presenters so that we can use that information for future CLEs in order to present programming and topics that are relevant to your respective practices. The last CLE this morning is going to be a wonderful continuation of the first two presentations. Our presenters are going to be Scott Wilson. Scott serves as the Chief Investigator for the South Dakota Medicaid Fraud, Abuse, and Neglect Services Unit within the South Dakota Attorney General's office, where he oversees investigations that protect both the integrity of the Medicaid program and the well-being of vulnerable individuals. Our other co-presenter here for the last CLE this morning is going to be Jody Gillespie. Jody serves as the director of the for the Office of Attorney General, Division of Consumer Protection Services, with a focus on investigation and enforcement of our consumer protection laws. Part of that role includes her educating the public to recognize scams and potential deceptive practices before they occur. So with no further ado, I'll hand it off to Jody and Scott, and we'll let them take it away. Thank you, guys.
Thank you. Like you said, my name is Jody Gillespie. I'm the Director for Consumer Protection on the investigative side. Click. Yeah. So part of our responsibilities lie underneath deceptive trade practice violations. Everybody always looks at you and goes, okay, what does that mean? Basically, it's when a business sets out to deceptively knowingly deceive a consumer, falls underneath our umbrella. We have about 17 to 18 pages worth of statute. I think that consumer protection is unique in the respect that, yes, we have our statutes, but because of the scams that go on, we tend to have a broader area that we have to deal with because the scams are always evolving. Currently, we have 6 investigators, 2 assistant attorney generals that are assigned to take our cases into court. We're pretty excited about that. We've typically only had 1 in the past, so we're pretty excited to bring on our second one in August. I have 1 complaint intake specialist that deals with all of our calls, complaints, and inquiries that are coming into our office. Last year, we took in approximately 68,000 inquiries from consumers, businesses, just inquiries and complaints. So extremely busy. We also participate, obviously, in multi-jurisdictional, multi-state cases across the nation where we band together to say that this company is doing XYZ poorly and it affects all of our consumers. So that's where a lot of our funding comes from. We also, starting this year, the legislature gave us another position to have a special projects. What that special projects position is going to do is help me get more information out to consumers, doing some different things to try and reach more consumers, not just our elderly, but our young consumers as well, teaching them a little bit more about things to watch for on the forefront versus on the back end where our office has to come into play. So we're pretty excited about that. So these are not new scams. These scams have been around. I've been at the AG's office for a long time. They're not new, but they're constantly evolving. Your phishing scams are still out there. You guys get the text messages. We've kind of got our consumers geared towards not answering those phone calls. If you don't know the number, don't answer the call. And we've gotten that kind of through to everybody. But your scammers use the text messages heavily. I'm just like anybody else. When that text message goes off on my phone, I look at it because that means somebody needs something. And so that's one of the areas that we're pushing heavily with our elderly consumers, that just because somebody texts you, it doesn't mean they know you. They have a number. It's still using an auto dialer to do those text messages out to zillions of people. And so that's one of the areas that we have focused heavily on. They're using those text messages for your Social Security scams. You're getting a new Social Security card. You need to call this number to activate it, or you won't have your Medicare benefits. And so that's one of the bigger things that has happened here probably in the last 5 months. We've gotten increased phone calls with this Social Security scam. Social Security is not issuing new cards out to people. There was here about 3 weeks ago, we got a rash of phone calls coming in where people actually did receive new Medicare cards. And it was because there was an issue with Medicare, and their Medicare card was compromised. So they reissued without those consumers having to notify Medicare. And so we did receive a number of phone calls regarding that and the legitimacy of it. So there are certain things that they are watching for. Your grandparent scam, still alive and well, still works. All of these scams are still here. They've been around for those 20 plus years, but they're still working. The evolving portion of the grandparent is a tag team. There's usually two scammers that are working this, and one is the grandchild that has been picked up for drugs. The other one is the attorney that is working for the grandchild to get him out of jail. And so they tag team with that to make that call seem more legitimate. Grandparent scams typically rotate about every 6 months, and so it's working well for them. Your lottery scams, alive and well. How many of you guys are millionaires? You guys have gotten the phone calls. All you got to do is pay your taxes. That is still working. One of the things that comes into play with this one is back in April of 25, Publishers Clearinghouse filed Chapter 11 bankruptcy. They were purchased by another company, and so now they just have that digital platform. That's all they have now at this point. But Publishers Clearinghouse is still working. We just actually, 3 weeks ago, received a call from a consumer that had been scammed on the Publishers Clearinghouse side of this. So that's one of the red flags. I don't see these going away. We see some different trends with this happening where they're going to be calling, your scammers are going to be calling people indicating that, no, we've got something worked out with that Chapter 11 bankruptcy that's going to allow us to go back into our records, and we see that you won. You just have to do this filing fee. And so we see that there's going to be some residual effects from this, but those are still there. Currently, right now, your home repair scams, as soon as a storm comes in, we call them storm chasers. You have them everywhere across the state. You have to pay attention to those. A lot of things that come into play with those storm chasers are door-to-door statutes. There are rules and regulations that they have to follow when they knock at your door to sell you that product or service. The thing that comes into play with these home repair ones is typically your door-to-door salespeople will set up and have a good rapport with the suppliers. And for the first 3 weeks, they will pay the bills, and they will pay the bills. And that third week, they go in and they say, oh, sorry, we forgot our checkbook. Can we go ahead and can we charge this? And the supplier looks at their records and they say, oh, sure, you guys have been good. We've got good business with you guys. And so they will take and they will let them charge for those shingles that they're going to deliver to 123 South Drive. And they say, well, we know where the product is going. Well, that the scammer never comes back and pays for those supplies. And so that company, the supplier, knows where they were delivered, and they put a lien against that property. So this consumer ends up having to pay twice for those supplies. So it's something that consumers need to watch for and pay attention to. Investment scams, they're alive and well. A lot that we see right now still in the wake even of the passage of Senate Bill 198, I believe, with the cryptocurrency. A lot of times with your investment scams, they are getting people to go and get funds and go to the ATMs that have that cryptocurrency capability or a kiosk and sending that money to a wallet specifically. And so we have a ton of that, unfortunately, right now. So we're hoping that with some of the new passage that will start in July, that will help us. There was also where they're able to do the seizure warrants. Those were somewhat difficult. Some of the legislation going back to the cryptocurrency stuff was that they have to give them a receipt. They have to give them a refund policy. They put the limits on $1,000 per day, because what we were seeing is consumers going and they had stacks of $4,000 and they're rifling it into a crypto ATM that had the cryptocurrency capabilities. They were rifling in like it was a lottery machine. And so those were some of the things that we were encountering. It affected a good chunk of our elderly consumers, but we were also seeing our younger generation also being targeted heavily with that. So we're thankful for that legislation, and hopefully we'll see some different trends with that. Your tech scams, these are still alive and well. We just got one here 2 weeks ago, Microsoft, where it pops up and Microsoft is monitoring your computer and there's something wrong with it. And they literally get these individuals convinced that they are in their systems. A lot of times what they're doing is and I'm not a computer tech person, but what they will do is they will get them to go to specific areas within that computer that are typically standardized, and they will say, see, your computer is at 900 megahertz. Well, your computer is supposed to be at 900 megahertz, depending on what you're at. But it makes that consumer go, oh, they can see what's in my computer, and they are watching, and they are monitoring. If you still are a little bit hesitant, they will take you to a second place on that computer, again, that's standardized. And they get you convinced that everything that you've done on your computer that the scammer is able to see. And what they're doing is having them go to their banks and pull out their money. And you can't make this stuff up. They are pulling out their money. We had an individual that pulled out $33,000 out of her savings account, took it, it's in a box at home. She waited for the scammer to call her the next day because the scammer was going to have a courier come and pick that money up to safeguard the money until they could get the computer system figured out. And so she did exactly what they said. And this is in a little small community up in the northeastern part of the state during the time when we should have been able to stop them. They had a little gentleman, there were two gentlemen in the vehicle. It was a black Ford Explorer that pulled up. It had Florida license plates on it. And she was told to take that box that had $33,000 in cash down to the end of her driveway. She didn't need to talk to the courier because they didn't know anything about this, just to drop the money off and they would get it safeguarded for her. And she did exactly what they told her to do. $33,000 drove away. They didn't contact us for 2 hours after it had happened, and by that time they were gone. Local law enforcement did some checking across the different counties and so forth, but it was gone. But that's Microsoft. Microsoft is a software program, and so these pop-up ads are still working for people. So people just have to pay attention. They have to do better at not accessing those things. And they're getting better. These guys, when we talk about having paper documents stolen, that does not take a particular skill set. Anybody can do that. When you start talking about tech scams, that takes a particular skill set. And so they're getting better at what they're doing. They are more savvy. We're kind of, in my opinion, we're kind of behind the 8 ball on some of these. So we're trying to catch up to some of these tech scams. People just have to pay attention. When they're using their smartphones, it's a small computer. They have to pay attention to what they're opening, what they're clicking on to make sure that they're not on open Wi-Fi, that their Bluetooth isn't on in certain areas, and those types of things. So how can consumers report those instances to us? We have our toll-free number, I don't know if I've got it up there, but we have a toll-free number that's 800-300-1986. If they have simple questions or they want to refer something, an email to us, we have a consumer help at state.sd.us that they can send messages to us. But we also have an online complaint form that consumers can submit their complaints to our office. Those are some of the avenues that they have. We like to hear the different traits that scammers are using because they're constantly changing and constantly evolving. And so when we get those calls in and they've changed things, that's the only way that we can turn around and alert consumers and businesses of the different trends that they're going to have to start paying attention to. Your business email compromises for businesses, those are still alive and well, still compromise businesses out of their hard-earned funds. Typically an invoice is generated, a fraudulent invoice, or a different bank account is activated that they want payments sent to. Those are the things that we try to help those businesses with. If they get those reported to us within the first 24 to 48 hours, we typically have some pretty good success in getting those funds back for them. The other one that's coming around, you've got your tech scams, you've got the newfangled ones, but we refer to them as old school scams. Probably about 12 to 15 years ago, you had your cashier's checks that were alive and well. That is making a huge comeback right now. So people have to pay attention to that as well. Those are fraudulent accounts that the checks are being given, and they won't know that until they go through the Federal Reserve as being a no-account check. The banks turn around and they come back to the consumer because the consumer is responsible for knowing what is going into their account, and the bank expects that payment back. Well, in most instances, the consumer has already sent the money back to the entity, the scammer, and so they're further in the hole than when they started. So that is something that is coming back around. Check washing is a huge deal right now. That's made a huge comeback. What we're seeing, they did have a gentleman out in the western part of the state that did get prosecuted for some check washing. We also have tracked down some individuals out of the Chicago area. It's organized crime where they're actually taking payments, big payments coming from Caterpillar, Butler, because they know that they're large dollar amounts. And so we're seeing those those checks being washed and used in a fraudulent manner. So those are just some of the things that people are encountering currently right now. With that, I'm going to turn it over to Scott. And I always, at the end, remember what Einstein said? Question everything. Be a skeptic. Start asking those questions. You cannot take people at their word, unfortunately. So ask the questions. So I'll turn it over to Scott with that.
Thanks, Jody. Thanks for having us. Appreciate it. We realize that we are the only thing standing between you guys and lunch. So we will do our best to get you out of here in a timely manner. As Jody said, my name's Scott. I'm an investigator with the Medicaid Fraud Control Unit. In South Dakota, we go under the acronym MFANS for Medicaid Fraud, Abuse, and Neglect Services. Can you guys hear me okay? I am completely deaf in one ear, and I can't hear myself, so. Closer? Thank you. Why is a guy from Medicaid Fraud here to talk to you about elder abuse? I think it's important to understand where we come from in legislature in the last decade or so in South Dakota. In 2015, the legislature impaneled a task force to study elder abuse and exploitation in the state of South Dakota. Excuse me. And the results of that and the recommendations from that task force indicated that they thought there was a problem with elder abuse and exploitation in the state. And they recommended some revision of statutory language, some criminalizing of some items that had not yet been criminalized under law, some increased penalties, and then a new unit to be formed ultimately under the Attorney General's office with an investigator and an attorney. And in 2022, I joined that unit, the Elder Abuse and Exploitation Unit. And then 2024, under Mandy's tutelage, we joined the Medicaid Fraud Control Unit due to some shared mission. Under the Medicaid Fraud Control Unit, our mission is to investigate and prosecute fraud in the administration of the Medicaid program and in the provision of that, of that program. But we also have the ability to investigate abuse, neglect, and exploitation in certain situations, including in the facilities that receive Medicaid funds, within the provision of healthcare services, and at our discretion in board and care facilities across the state. So with that, it's important to realize we are funded 75-25 by a federal grant. We, when fully staffed, have 9 full-time employees. But most importantly, we don't work in a silo. We work with all of our partners across the local, state, and federal entities to achieve this mission. I think it's also important to realize that although we're doing well in South Dakota, we don't protect our elders like we protect our children. Although we talk about life coming full circle, being dependent when we're young, and eventually living our life and becoming dependent again when we're older, we don't afford the same protections to our adults and our elders and our adults with disabilities that we do our children. We don't offer the same protections. We don't offer the same mechanism for removal from harm. And we don't offer the same placement opportunities. While I was sitting in back, I did a Google search. South Dakota currently has 908 licensed foster care families. My family's one of them. Did anybody know that we have an adult foster care program in the state? We do. There are 4 licensed homes currently, and there is not one adult in those 4 licensed homes last time I checked with DHS. That does not include the VA's foster care program. So what is elder abuse? But more importantly, what's an elder in South Dakota? An elder is not always defined the same across states. So in South Dakota, we define an elder as someone age 65 or older. But in South Dakota, we protect our adults with disabilities the same way we protect our elders. And we define our adults with disabilities as an individual 18 years or older who has a condition of intellectual disability to the extent that they're unable to provide for their own care. So some quick definitions, and then we'll get into some case examples. Physical abuse is simply physical harm, bodily injury, attempt to inflict harm. Think simple assault. The legislature in 2016 was nice enough to amplify the penalty for that. So instead of it being a Class 1 misdemeanor, it is a Class 6 felony. It's the only increased penalty we got other than criminalizing psychological and emotional abuse. So where do we see physical abuse? Obviously, we see it in homes with family caregivers, family members. We see it in the provision of medical services, in nursing care facilities with frustrated staff, short-tempered staff, tired staff, underpaid staff. And we see it across all spectrums. And it's certainly one of our primary areas of focus. Emotional and psychological abuse, again, criminalized under the 2016 legislature, talks about sexual acts, the simulation of a sexual act, unreasonable confinement, harm, damage to the property of pets, ridiculing or demeaning conduct, derogatory remarks, verbal harassments, threats to inflict harm. That's usually what we see. We see the demeaning remarks, the verbal harassment, those sorts of things. We primarily see it in our facilities, unfortunately. Again, underpaid, tired staff. We've had cases of a family member trying to get mom into the car, mom's having difficulties. The family member is screaming, yelling, swearing, pushing mom into the car, making a scene to the point where people stopped, paid attention, and reported it. Recently had a case, ultimately cleared itself, but we had a case where an individual was placed into a long-term care facility against his will. Again, those levels of capacity, and that was kind of what was at play. An individual, a family member, had gotten guardianship, placed him against his will in a care center, helped himself to some of the finances, but ultimately the individual didn't want to be where they were at. They wanted to be in a different state with a different family member, and that ultimately was affected, and that's the outcome. Neglect is the harm to the health, welfare of an individual without reasonable medical justification caused by a caretaker within means available, including food, shelter, clothing, medical care, etc. But it's important to realize that within the definition of neglect under the abuse and neglect statutes under 2246 is that it specifically states that it has to be a caretaker. So let's define caretaker quickly, because in order for us to even consider a case of neglect, we have to identify a caretaker. Caretaker is a person who's entrusted with the property of an elder or an adult with a disability, who's responsible for the health or welfare, and who's assumed a position of trust or responsibility, either voluntarily, by contract, by receipt of payment, or by order of the court. And we talk about, voluntarily, that's someone that is shown through a pattern of behavior that they're helping the person. It could be a power of attorney. It could be a paid caregiver through a home health care agency. It could be a court-appointed guardian, et cetera, but it has to be that caretaker. Some examples that we've done, we have had family members move in with our victims. They regularly saw the doctor, was one of their social outings. Once the family member moves in, they stop going to the doctor. If they go at all, it's the emergency room. They're not complying with medications. The pattern of behavior changes once the caretaker comes into play. Elderly bedbound man being taken care of by a family member who works all the time and leaves the guy to lay, doesn't get fed very frequently, probably develops bed sores, that sort of thing from not being moved. And then just generally, what we see the most, I think, or at least commonly, is caretakers who think they know better than the medical providers, and they fail to follow the medical care plan. And I'm not sure why it's doing that, so I apologize. So what we see most in our office right now, and it's probably because elder abuse and Medicaid fraud joined, and we were the primary recipients of the referrals of exploitation. We are seeing a lot of exploitation referrals, a lot of big dollar exploitation referrals. And again, exploitation is defined under state law. Any person who has assumed the duty to provide support to an elder or a person with disability, again, voluntarily, by contract, by receipt of payment, or by order of the court, and who's entrusted with the property, and then they use that property effectively to their own benefit or for an unlawful way. The issue that we have with exploitation is it's strictly punishable under the theft statutes in South Dakota. So we have to meet the additional elements to charge the offense, but it's still just punishable under 2230A. So it's something that we look at, it's something that we use as an alternate charge. It's certainly something that when it's seen, it has a certain perception, but ultimately it's just chargeable under theft. And we talked about the duty. People talked all day about guardianship, conservatorship, powers of attorney. We deal with guardianship, conservatorship, power of attorney all the time. As we know in South Dakota, every power of attorney is written differently. Some are very vague, some are very descriptive. And one of the first things we do when we get a case is to get a copy of those powers of attorney. And we talked about that appointed duty, generally the voluntary duty, which would be a family or a friend. When we talk exploitation, generally what we see are family members, and this is what you'll see as attorneys when families come to you. It's almost always a family member or a close friend. They make their way into an individual's life. They may become power of attorney. They may become guardian or conservator. And they are quickly motivated by the victim's funds. I haven't seen more families torn apart by anything faster than money. We have several very large cases going right now, nothing that we can go specifically into. We actively have cases well in the 200,000, 300,000, 400,000. I've got one exploitation case that's over $1 million pretty easily right now. It's just sad to see that somebody's entire nest egg can be taken from them in just short, quick time frames. The typical investment schemes with family, that happens all the time where the money really goes out to unapproved items, purchases, cars, trucks, boats, etc. We've had a fairly large case that involved the mortgaging of mom's land in South Dakota. Maybe people aren't cash rich, but a lot of people are land rich. So we're starting to see a lot of transfers of property. A lot of ag land being quit claim deeded and then later sold to the benefit of our perpetrator. Those are things to look for. We were talking, or they were talking earlier about capacity and victimization, and I think it's important to look at some of the factors that play into vulnerability. They were talking about cognitive capacity and the levels of capacity and how somebody might have the capacity to make one decision but not the capacity to make another decision. Those are all things that come into play in our investigations. That cognitive decline or that cognitive impairment is really a factor towards vulnerability here, as are the physical limitations. People aren't as mobile as they were. Older people maybe don't have the same access to or ability to use technology to check on their accounts and to communicate that way. That can lead to social isolation, whether at home, at a residence, or whether they are in a care center. And you combine the cognitive decline with the social isolation, and it lends people to be a little more easily influenced by people that do come visit. So maybe one family member endears themselves a little bit and is able to make their way into that individual's inner circle. Financial vulnerability, as we talked, the older population I can't remember what they say, something like 60% of the nation's wealth is the baby boomer population and older, right? My parents are of that generation. They're starting to make the decisions about what's going to happen to them in the future. Hopefully, listening to the last presentation, there's some good takeaways there because an ounce of prevention is worth a pound of cure, right? If we prepare well now, then people like me don't have to pick up a case of exploitation or abuse later. Hopefully, that would be the idea anyway. And not just making plans for where you're going to go, but make plans for your money, make plans for your land, all your assets, your properties, your businesses, et cetera. Attrition plans are important. We've seen a couple cases where family businesses have basically been stolen by unscrupulous family members. Another thing that we often see is where the spouse that was the primary person responsible for the finances passes away, and the second spouse doesn't have much familiarity with the finances. Maybe they don't even know how wealthy they are or aren't. But certainly because of that, it makes them more vulnerable. And I think with any of this stuff, whether it's a scam, whether it's being taken advantage of, there's that embarrassment that comes along with it, and so there's a lack of willingness to report. And if you don't report it, we can't investigate it. If we can't investigate it, we have absolutely no opportunity to get the funds back. Some common signs, symptoms, and stuff that can indicate concerns. When it comes to abuse and neglect, those behavioral changes that they were talking about earlier, increased anxiety, depression, fear, withdrawal, those are real. These people have a world of experience, literally an entire lifetime of experience. They know when they're being treated poorly, even with some limited capacity. On the physical sides, dehydration, malnourishment, maybe they would require a walker, a wheelchair, a cane, but they don't have one, and it's not being provided to them by their caregiver. The inadequate or inappropriate administration of medications is something that we see fairly frequently. And again, I mentioned it, but that use of the emergency room rather than a primary physician that establishes a relationship with the individual, it's so much easier to spot when a doctor has a relationship with the victim versus when they're just bouncing from clinic to clinic or emergency room to emergency room. On exploitation, the things that we see the most are changes in spending habits. If grandma's in care and has never used an ATM or has never used Venmo or PayPal or Cash App, if there's PayPal and Venmo and Cash App and ATM withdrawals while grandma's in care, that's a sign. And generally, that's what we see, somebody that has access. And like most thefts, they usually start out low and then they grow as they don't get caught. And then again, just to reiterate, that thing that we're seeing now, or that at least is being alleged pretty frequently, is the fraudulent transfer of land. Land is worth more and more every day. And when people see the dollar signs associated with the potential sale of land, they get highly motivated to somehow get that for themselves instead of to give it to the long-term care center for mom or grandma. All right, so in South Dakota, we have specifically listed mandatory reporters for abuse, neglect, and exploitation. It's pretty much anybody in a healthcare or government position. So if you are in government or healthcare, assume that you are a mandatory reporter. That could include some of you. But more importantly, the majority of you would fall under the voluntary reporters. And it's important to realize that even if you're not compelled to report, it's important to report. This is, somebody's physical, emotional well-being, it's somebody's financial well-being. And South Dakota law urges you by giving you immunity for liability for reporting suspected abuse. And I think that, it's important to realize that if you don't say something, no one else is going to. So what to report? This is the simple who, what, when, where, sometimes why. But it's not just who the victim is, it's who's suspected. How are they related? What do they drive? What did they do? And if you're in a position where you can document the situation, That's ideal. Are there photos? Is there audio, et cetera? Tell us exactly what happened. Give us the dates, give us the times. If you don't know the subject's name, give us a description of the subject so that we can try to piece it together. And where did it happen? Obviously, venue is important. So tell us where it occurred so that we can go back and try to get video or audio or even know where to bring a charge if that's possible. We get most of our referrals through the Department of Human Services, through Adult Protective Services. They have an organization called Dakota at Home. Dakota at Home is a one-stop shop for reporting abuse and exploitation. And for things that don't necessarily rise to the criminal level, that's a great place to start. It gets that situation in front of Adult Protective Services, probably gets a specialist assigned, and ultimately gets the ball rolling. Again, those mandatory reporters are mandated to report to the Department of Human Services. Thanks to the legislature in 2016, they're also obligated to report to the Attorney General's office. That's us. And so we received, I don't know what the exact number is, but I think it was over 2,000 referrals last year on abuse, neglect, exploitation, Medicaid fraud, everything within our office. And so we triage it, and we may not open a case on it, but we will do our best, if it warrants, to get it to the appropriate agency or law enforcement entity. So if you report to DHS and they report to us, or if you report directly to us, we will do our best in our group to get it to where it needs to be. We certainly interact and work well together. When we do take a case, just so that you guys are aware, we assign an investigative team to that case. We assign an attorney that is part of that case the entire way. We assign at least one investigator, and we assign an analyst if the case is a financial case or if it warrants a deep dive into medical records and things of those natures. And again, we do our absolute best to get referrals to the appropriate places. So if the only takeaway you get is my phone or email address at the end of the day, I will do my absolute best to get that to where it needs to be. If you work for a financial institution, the banking statutes also were updated to allow financial institutions to report to law enforcement the same information that they would submit in a SAR to FinCEN, a suspicious activity report. The dirty little secret with SARs is most of us don't see them. And so if you work for a bank and you submitted a SAR, it's unlikely to see the light of day. So also report it to law enforcement, please. Whether that's our office or local law enforcement, you have that legal authority, and you can provide the same supporting documentation that you would under the FinCEN rules. When we do take a case, obviously we assign that team. I indicated that we're kind of financial exploitation heavy right now. That, I mean, is obviously something we're working on with our partners, but that's okay. Those are true losses and they fit the program. With that, we do have some special authority, I guess, if you will. Again, in 2016, they added to the unfair trade practices statutes a section that compels a financial institution to comply with a reasonable request from a law enforcement entity doing an investigation of abuse, neglect, and exploitation. So we subpoena that information, but we do send a subpoena out, get bank records, and then we do have a criminal intelligence analyst that does do a very thorough review of those. And then, of course, our general subpoena power. We talked about guardianship and conservatorship, and I think that those things are great, and we often suggest that families look at that as an opportunity. Obviously, we don't give legal advice, but it's one of the options out there. One of the lesser known items that also came about in 2016 are vulnerable adult protection orders. They're very much similar to a domestic protection order, but they do allow for a substitute petitioner. So the victim doesn't have to walk that petition and affidavit to the clerk's office. An involved other witness party is able to do that. I know that APS has helped with some of these. I know that some families have used this. It's a tool that's out there. It's obviously a civil tool. We can't do it as a law enforcement agency, but it's something for your clients to consider. And ultimately what it does is it can remove the individual. That could separate the parties, remove the suspect, or suggest alternative arrangements for the victim. And then it also pulls whatever financial authority the subject would have during the period, whether it was a temporary, ultimately a permanent protection order. And just like domestics, permanent, it's still a maximum of 5 years. Because we are a Medicaid fraud control unit, we take abuse, neglect, exploitation, and provider fraud seriously. And just as a caveat, if the abuse, neglect, or exploitation is perpetrated by someone that is providing healthcare services, whether it's a home health nurse, somebody in a care center, if we are able to convict them on those charges, then we also send them to the Department of Health and Human Services Office of Inspector General for exclusion, which then precludes them from working from any facility that receives federal health care funds. And depending on the charge, it's a different prescription at time. But it's important to keep those perpetrators out of our facilities that have vulnerable people. All right, I have hit the end in the question and answer portion. I told you we'd get you out of here early. It is 11:20. Does anybody have any questions for Jody or I? Yes.
I couldn't project all the way to the back of the room, so I'm going to come up and use the mic. So Jody, I know you talked a lot about this is not a South Dakota specific, it's everywhere. And a lot of times in my practice, I've seen it nationally and even globally with scams. My question is actually for Scott of, are there other, similar agencies in other states that you guys work with if you have instances? I understand a lot of it probably is located in South Dakota, but for instance, I have a case that I had to be a part of last year where, an elderly adult person was transported by family 1,500 miles to South Dakota. He was left at a hospital with a birth certificate, a divorce certificate, his driver's license, and social security card, and that was it. And wondering if you are working with other states too that have similar agencies to combat this, as it's not just probably a state-specific issue anymore.
Right. So as I indicated, we don't do any of this in a silo. Although we are a state agency, we work with our federal partners, and all 50 states and 3 of the territories have Medicaid fraud control units. Some other states also have elder abuse and exploitation units. And we do work with our partner agencies. We've had to do, and we also work with like Health and Human Services when it comes to if there's Medicare components, et cetera. Work very, very closely with one of their agents here. It's important for us to keep developing those relationships. It's really easy to stay in our little circle, but to your point, we've had some situations recently where we've had to rely on our partner agencies in other states to help us make our case. And we've been relied on by other states to help them. And certainly, absolutely, it's a priority when we are asked for assistance. We jump in, and we hope that we're given that same priority when we ask for assistance. Anything else? I guess it's lunchtime.
Thanks, everybody, for attending. We're going to put up the QR code here in just a second for giving feedback. We really appreciate it on behalf of the State Bar CLE Committee. Thank you guys so much for everything today. Thank you to our presenters, and have a great rest of the afternoon.